Good afternoon, ladies and gentlemen. Welcome to the George W. Norris Legislative Chamber. The afternoon session is about to reconvene. Senators, please record your presence. Roll call. Mr. Clerk, please record.
There's a quorum present, Mr. President.
Thank you. Do you have any items for the record?
I do, Mr. President. Motions to be printed from Senator Hunt to LB 214, Senator Kavanaugh to LB 220, Senator Hunt to 227, Senator Hunt to LB 249, Senator Kavanaugh to LB 254, and Senator Kavanaugh to LB 256. That's all I have this time, Mr. President.
Thank you. Under the south balcony, a guest of Senator Geist is Bud Henderson, her father, celebrating his 90th birthday. Please stand and be recognized. Mr. Kirk, we will proceed to the first item on the afternoon's agenda.
Mr. President, Legislative Bill 683, when the bill was left to recess the body, there was a bracket motion pending from Senator Conrad.
Senator Mosier, you're recognized to speak.
Thank you, Mr. President, and good afternoon. I also serve on the Telecommunications Committee, and we've discussed this bill, obviously, and we voted it out. I think that I have a little different perspective maybe than some on this. When we think of the Public Service Commission, we usually think about phones and broadband, but they have a pretty wide scope of work. From their webpage, it says they regulate telecommunications carriers, natural gas, jurisdictional utilities, major oil pipelines, railroad safety, household goods movers, passenger carriers, grain warehouses and dealers, construction of manufactured and modular homes and recreational vehicles, high voltage electric transmission lines, and private water company rates. So it's a very wide scope of work. And I think to this point that they have attempted to promulgate rules for wide access to broadband at reasonable rates, but I think it has been a complicated process. And I think having a person whose first responsibility is broadband is probably good to keep our focus on broadband. What I hear from people on broadband in my district is that broadband is mostly available, and it's not, there is competition and you have multiple people to get internet access from, but that I think most would prefer that it was easier, less expensive, and more available. So I think that's the reason for the bill. And I have a couple of questions. I was wondering if Senator Geist might respond to some questions.
Senator Geist, would you yield to some questions?
Of course.
Thank you, Senator. We were just talking about this a little bit before. Why do we need 10 people to have this new office, and where are they coming from, and what are they going to do to stay busy?
Well, let me answer this kind of on a high level. First, the PSC has already hired 3 people. Those 2 of the 3 are going to migrate over to this office. 1 potentially may. There's also, as I said earlier, the administrative costs of this, or the administrative rules of this office are going to be housed at DOT, Department of Transportation. So there's a number of FTEs in that office that will be applied to this. Plus, one of the things that the body needs to understand is there is a $5 million administration fee that comes to the state to pay for administrating this fund. So those dollars will be reimbursed to the office by that BEAD funding. And so this will, even though we have to pay upfront, we will be reimbursed as a state from the BEAD funds for those administrative fees.
Okay. And what are these people going to do?
Yeah. Here, I can read some of that. Well, of
1
course,
minute.
the director. There's an assistant director, an auditor manager, budget and finance person, a senior counsel, grant auditor, program manager, outreach coordinator, a grant accountant, an administrative assistant, human resource specialist, technical assistant. So I can't underestimate the magnitude of this funding and all of the federal strings that are attached take a broad array of people and specialists to actually implement this. So it's not frivolous. I will speak in a few minutes, I think I'm coming up in the queue here, about what the governor's intent on this is not. And that is, it's not to set up a new agency.
That's your time, senators.
Thank you.
And Senator Geist, you are next in the queue. You're recognized to speak.
Perfect. Thank you. The governor's intention, as I was saying, is not to set up a new agency. If he were to do that, he would have a broadband agency. Instead, he's appointing the single coordinator, housing those administrative roles within Department of Transportation where those roles are already somewhat taking place. And then having this person have relationships with the PSC, with the committee, and answering directly to the governor. So it's actually a very streamlined process. It's to administer and deploy these funds and this construction project. So the governor's intention is not to expand government, but it is to be efficient in the deployment of this project. I also wanted to speak to one of the primary roles of the PSC that has not yet been spoken to, and one that will carry on even after all this capital construction through BEAD has taken place. And that is with the Universal Service Fund. Currently, the Universal Service Fund is given to, it's taxed, basically, from voice services. So it used to be just voice services over copper wire, which all of us had. Well, now with the landlines decreasing, and I could ask, but I won't, how many people continue to have a landline in their home, and it's very few of us. There is also a taxation of the voice part of the internet, so voice over IP. There is a small tax on that voice part that goes to the Universal Service Fund. Many of those dollars are given to people who have constructed broadband or telecommunications within their communities. And this goes to help supplement the hard-to-reach people in high-cost areas to make that more affordable so people can have broadband in their community. The role of the PSC will be, and is currently, but this will grow. The question is, since single voice services are dropping and broadband is expanding, how, once we get these millions of dollars deployed, we reach some very expensive, hard-to-serve areas of the state, how, as a state and as companies who deploy this broadband, how are we going to maintain it? Much of that could potentially be through the Universal Service Fund that comes from state dollars. Now, those dollars are taxed the way that I just outlined a few minutes ago, but the PSC is probably going to, and this is its job, is to figure out, do we need to expand how we charge for the Universal Service Fund? Do we need to change that? How are we going to support this huge network going forward? Right now, that is the big question out in the future. It's one that has yet to be answered. It needs to be answered with the Universal Service Fund from the federal government, and if that's going to be taxed differently or charged differently, and then that will also dictate in some terms what we will do locally, though we're going to have to address this locally. So that is what currently, it's a big job. It's going to be a contentious discussion, but going forward, we need to decide, and this is squarely in the purview of the Universal Service Fund. We're going to need to decide how are we going to tax, what are we going to tax, and will this be sufficient to support the network that we're looking to build through this coordinator. And with that, that's all. Thank you, Mr. President.
Thank you, Senator Geist. Senator Dungan, you're recognized to speak.
Thank you, Mr. President. Colleagues, I rise today with questions about this bill. I apologize, I was just running in from the back there. So I've heard a lot of questions and a lot of comments about LB 683, and I'll be honest, I've not come up with an opinion yet about how I actually feel about it. My reservations, however, come from the legal portion of this. And what I mean by that is on page 5 of what we're talking about here, there's a portion that goes into the essentially the appeals decision for any decision made by the Nebraska Broadband Office. And I want to talk about that a little bit. And if I run out of time, I'm going to punch in again. So in that it says, if any final decision of the Nebraska Broadband Office relating to funding for broadband projects is appealed to district court, the appeal shall, except as to cases the court considers of greater importance, take precedence on the trial docket over all other cases and shall be assigned for hearing, trial, or argument at the earliest practicable date and expedited in every way. So when I look at that, that sparked about 1,000 questions in my mind. And what I mean by that is this seems to essentially create a separate cause of action wherein if the Nebraska Broadband Office makes a decision, somebody, and it's unclear who, can then take that case to the district court. But that seems to be entirely outside the purview of the APA and the regular appeals process for administrative agencies. So there's a number of questions I have about that, and I was wondering if Senator DeBoer would yield to a few questions.
Senator DeBoer, will you yield to some questions?
Yes.
Thank you, and I'll try to make this as quick as possible, but you and I have had a conversation about this off the mic, and we'll keep talking about this. But my first question is here, who can appeal or who can take this case to the district court? Who does this particular provision pertain to?
Well, it would probably arise in those instances where there's a challenge as to whether or not a project is appropriate in an area based on its servedness, as I talk about it. So an unserved carrier or a carrier in an area that is purported to be unserved might say, I'm challenging your ruling that in fact it was served or something like that. So these would generally be people who either were applying to grants for a project, or it would be the people who, or the company that already exists in that area appealing in order that it was unserved.
So could a person, or I'm sorry, could a person or entity who's asking for a grant who doesn't get quite as much money as they want, could they bring that case to the district court?
My understanding is that they usually say this is the amount that we want for the project, and then the project is either approved or denied. I know there is some exception where they have an area that they've discovered there are a couple of random locations served, and then it would be discounted by those particular amounts. So possibly is the answer.
Possibly. Okay. And that's, I think, the gist I'm trying to get at here, and I'll talk more about it too, is that there's a lot of undefined things in here that I think should be clarified. Where would the case, which district court would this be in?
Lancaster County District Court handles all of our APA appeals in Nebraska.
But if this is outside of the APA, if this is just a separate cause of action, would you be able to bring this in the district court, say, of the area where the grant was being sought?
So my understanding is this is not a separate cause of action. I know you and I talked about it, and we need to clean up the language perhaps
1 minute.
to make that
Thank
clear, but this is not a separate cause of action. This would be any appeal that arose out of the normal course of an APA appeal.
And do we have in here what the burden, who has the burden of proof essentially to show that this decision was made incorrectly?
I believe it's de novo in Nebraska for APA appeals.
So again, the intent of this was to make it a normal APA appeal, not to create.
Absolutely.
Okay. The part in there, I'll save that for the next time on the mic, Mr. President. Thank you, Senator DeBoer. I'll ask you some more questions here in a little bit.
Thank you, Senator. Senator Michaela Cavanaugh, you're recognized to speak.
Thank you. Thank you, Mr. President. Good afternoon, colleagues. Okay, so I feel like it remains unclear if we are creating a new agency or not. And I know we don't have the committee amendment up here, but I think that we'll be getting to that shortly. So I'm going to speak to the committee amendment because I'm running on the assumption that that's what we're going to be working with. So on the committee amendment on page 4, lines 9 through 20, this is where I don't know if I'm reading this. I honestly don't know if I'm reading this incorrectly or not. And I will have continued conversations with our legal counsel on the committee about this. But it says that on line 13, to accomplish the intent, the Nebraska Broadband Office is created. The office shall be headed by the Director of Broadband. The director shall be appointed by and serve at the pleasure of the governor with the approval of the majority of the legislature. That to me sounds like we're creating a new agency. I know that their administrative costs are going to be absorbed by the Department of Transportation, but there isn't a date in here where we sunset this office, where it ceased to exist, which is a pretty big concern to me that we would create a new office in such a manner. I don't know when the last time is that we created a new state agency, but with one directive, which is this grant program, the BEAD program, and believe me, this is not on the merits for me of the BEAD program being in one agency or the other. It's really about what are we doing long-term here? So this is a granting program that started with the Public Service Commission. And what this bill seeks to do is to move that specific program over to the governor's office and create a new department, is how I'm interpreting it, as creating a new department. The granting program ends, I believe, January 2028. What then for the Nebraska Broadband Office? What directive are we giving this office? What funding are we giving this office? What is the intention behind the work of the office? I think these are really substantial questions that we don't have answers to. And of a lot of things that I've opposed this year, I'm going to be honest, this is one that I'm not feeling great about opposing because I am standing up against my entire committee, and I very much enjoy the Transportation Telecommunications Committee, and I very much enjoy serving on it with all of the other members. So this is not at all enjoyable for me to stand up solely alone in opposition to this. But I am concerned. I'm very concerned about what we are doing because we could not do this, and the granting process, the strategic plan, could continue under the PSC, and we could collectively work to figure out the path forward. We can let the PSC continue to run the strategic plan. They probably would continue to do it in consultation with the Department of Transportation.
1 minute.
And we could have an interim study to see if it was appropriate to set up this new state agency. And frankly, it probably is necessary to create a new state agency for broadband. I don't disagree with that concept, but I do disagree with doing it under the guise of moving a specific short-term federal program from an elected body into the governor's purview without more thought and discussion around it. So there's a lot more to unpack on this bill. And I know I'm committed to taking a lot of time on bills, but I really do have a lot to unpack on this bill. I truly do. And I think that others do as well. I think that this is a significant step for us to take as a legislature, and I hope that others will join in the conversation because we are ultimately creating a new state agency here, not
that's
just
your
moving a
time,
program.
Senator.
Thank you.
Thank you, Senator Kavanaugh. Senator Bostelman, you're recognized to speak.
Thank you, Mr. President. Good afternoon, colleagues, Nebraska. I want to read, this isn't unique to Nebraska. 35 other states already do this. So this is from NCSL's website, and I'll read this to you. With roughly 9 out of 10 adults, again, I do not support the bracket motion. I do support 683 and its amendment. So with roughly 9 out of 10 adults in America using the internet, many consider it to be a necessity of modern life because access to the internet is unavailable or inadequate in parts of the country. States and the federal government are focusing on deploying broadband, the technologies that allow internet data to be transmitted at high speeds as universally as possible. More than half the states have active commissions, council, task force, offices, etc., to help develop and promote broadband use. The advantage of creating a statewide broadband authority is that it can, 1, provide input to the development of statewide broadband framework and plan, 2, promote public-private sector participation, 3, develop a broadband map to determine unserved and underserved areas, 4, to administer and assist with funding programs, and 5, assist with encouraging adoption, use, and digital literacy. At least 35 states have created a governance structure through statute. So this is not something new. This is something that is done by other states. In fact, a lot of the modeling that we're doing, my understanding that they're looking at the broadband office now, is looking at what Colorado's doing. We have been on the back burner on this issue for years. This is something I've been trying to get us to do for years. Establish a broadband office so as these funds come about, we're ready to not take what we're being told we're cherry pick this village, this town, this city, and we're going to build out there. We're not going to do that. What we're going to do is say, no, the unserved people live over here, and that's where we're going to apply the grant to. That's what we're talking about. My concern. That's why we need to get the map done. There has not been a map done by the PSC. There has not. I have tried for years to get a mapping bill done. Couldn't get it out of committee for years. Last year, we did get a mapping bill done. PSC just in January cut a contract with a company to do mapping. But that mapping is going to be done using federal information. And my concern is we're not going to get any better map done with them than what we have right now, than what currently exists through FCC and the 477 process. We need to have an accurate map. We need to have an address level map. We need to have people on board within a broadband office that understand that will drive that will make that happen. This isn't something that we can wait 2, 3, 4 years on. This is something we need to do now. There is hundreds of millions of dollars that potentially will come to this state if we get our maps done right. And we need an office that is solely focused on taking those funds, understanding the need in the state, and delivering the funds into those areas to those people that need it the most. That's what we're trying to do with this. That's what this broadband office is all about. Senator Geis talked a few minutes ago about the NUSF and USF funds.
One
Got a
minute.
bill. I've got a bill, folks, LB 722. It's in the other committee priority bill. It addresses that. I have worked with national attorneys, national telecoms on this bill. It's not done anywhere else. We've got the template, I feel, to make this happen. We're putting it on the table. We want to make sure USF funding is used in the right way. We're not utilizing it twice in an area. We pay once. We make sure COLA responsibilities are where they're supposed to be. We encourage and to look at what we need to look at in the future, which Senator Geis is right, is what's going to happen in those areas that aren't currently covered. How do we fix that? And that's what the bill 722 does, is to put it on the table. Let's address this. Let's work on this over the next year, 2 years. We're going to learn a lot more about that. And again, this has national input to it. It's just not something we've done locally. And it took over a month of negotiations to make it happen.
That's your time, Senator.
Thank you.
Thank you, Senator. Senator Dungan, you're recognized to speak.
Thank you, Mr. President. I wanted to pick up a little bit of where I left off earlier. So again, I'll admit that I'm sort of playing catch up here. I wasn't a part of the committee. I wasn't a part of the hearings about this. But when I was reading through this in preparation for today, just to give a little bit of background, we got to this section 3 that I read on the mic earlier. And it just raised questions, because rather than referencing, say, for example, any appeal to a decision made by the Nebraska Broadband Office shall be conducted under insert relevant statute here with regards to the APA, it instead says that it can be taken to the district court. Now, my understanding is from speaking with folks about this, because I've just had a lot of questions, the language on here was, I think, adopted intentionally from the Open Acts statute or the Public Acts statute. And so that's where this language comes from. But again, a number of the problems that are raised when we look at this is when a case is appealed to the district court, first of all, just to make sure we all kind of know what we're talking about, we need to even know what we're talking about. So at the very end of this, it says that it shall be assigned for hearing, trial, or argument. So those three things, a hearing, a trial, and an argument, are obviously very different proceedings before the court. And so what I don't understand in looking at this is how this would even formalistically look. Is this appeal to attorneys arguing on behalf of their prospective side? Is it a trial wherein actual evidence needs to be presented? Would somebody be eligible for a jury trial, for example, or would they only be eligible for a bench trial in front of a judge? Or is it simply a hearing wherein they make arguments to a district court judge and that district court judge makes a decision? Are they entitled to counsel at that? Another question that really popped up here is who would be representing the Nebraska Broadband Office before the Attorney General? Is that going to be, before the district court? Would it be the Attorney General? Is that who is ultimately going to be defending the decision from the Nebraska Broadband Office? And so even just sort of logistically, what kind of hearing we're talking about, I think, is a little bit confusing, and I would love some clarification on that. In addition to that, when it says in here, except as to cases the court considers of greater importance, they're essentially saying that these appeals from a decision made by the Nebraska Broadband Office should go first unless the court has a case of greater importance that they have to first determine. I think what I find confusing about that is, in my time working in and around the district courts, they don't rank their cases. There's not a list of higher priority, and it's essentially always a moving target, right? So a case that maybe is a lower level criminal offense, for example, could take priority over a higher level offense if it's been pending for trial for 6 months versus a case that's relatively new. And so the fact that there's all these moving pieces and parts to all of that, I think makes it very hard to define what is a case of greater importance. And also, having worked in the court system, I can tell you that our courts are very backlogged right now. We have district courts that are very, very backlogged. There are civil trials that get set that sometimes don't happen for 9 to 10 months after they've originally tried to set a trial. I've had criminal cases that have been continued time and time again because they just don't have time to hear it. And so if you start taking things like these decisions and inserting them before other parts or other things the district court's going to hear, I think it just becomes somewhat problematic. And so the reason I was asking Senator DeBoer those questions is I just think that Section 3 of this needs to be fleshed out. And if we're going to have this go to the district court,
1 minute.
thank you, Mr. President, as an appeal process, I think we need to know who's bringing the case, who's eligible to bring the case, what's the standard of review, who has the burden of proof to show that this was wrong. If it's an evidentiary hearing, I think there needs to be some discussion as to whether or not a transcript needs to be kept by the Nebraska Broadband Office in order to be reviewed at the hearing or presented as evidence. And so there's just all of these questions I have. And so, Senator DeBoer, would you yield to just one more question here before we wrap up?
Senator DeBoer, would you yield to a question?
Yes.
Are you and others in the committee willing to address these problems and have conversations moving forward to clarify some of these answers with regard to the appeal process?
Absolutely. And between now and select file, I think we can do that. Some of this is standard APA procedure. And so there are some things that I think we can reference other statutes that might help to clarify some things in and of themselves. And the rest of it, I think we can clean up with language. I think you are articulating exactly what the
That's your
intention
time,
was.
Senator.
Thank you.
Thank you, Senator. Senators Dorn, you're recognized to speak.
Thank you, Mr. Speaker. As best I could, I've been listening to this conversation here as we've gone on today. I guess I want to bring up this point was many senators talk about when they ran what the top topic was, whether it was, the university or property taxes or other things. Since I've been up here in the legislatures, one thing that we've continually heard about is broadband, the lack of broadband as we have across the state. COVID brought that out big time. We've dealt with this a lot. We've had a lot of proposals, a lot of thoughts, a lot of comments. And yet I think most people probably agree that we need some type of person to do this or to help spur along the Public Service Commission. And I'm not faulting them or whatever, but it just seems like we haven't near progressed at the rate we should, or at the rate maybe other states have progressed in this. Broadband is one of the most important things for the economic activity in our state of Nebraska, and to make sure that everybody has the availability of that. I remember Senator Brandt and I came up here together, and Senator Brandt, when he came up here, one of the things he latched onto that one of his priorities has been this broadband, and the fact that we have counties out there today that because one person has broadband in that county, federally or statewide, they count the whole county as having broadband, and yet we know that maybe only 10% of those people have that. Down in my county, Gage County, they took part of their ARPA money. They have developed a plan whereby through some different things or whatever, they're going to have that whole county so that we can have adequate broadband coverage. They went through a lot of these processes. One of the board members down there, Emily Haxby, has worked nonstop, tirelessly on this thing for the last 2 years. They have a half-inch thick book that they now have as kind of their guidelines or whatever. And they are still running into issues. The longer we delay this, the longer we put this off, it means we are just that much farther out there to get broadband to everybody in the state of Nebraska. And been visiting a little bit with Senator Michaela Cavanaugh, and she gave a handout that the Public Service Commission had, and it's called the Broadband Equity Access and Deployment BEAD Program, and it's given the timeline of this. And as I read through it, most of this stuff I didn't know because I wasn't on the committee, but as you read through this, they have a process whereby they're going to do the mapping and that type of stuff. The initial proposal is supposed to be back here December 27 of 2023. The final proposal is due February of 2025. So that means now we're putting this off almost another 2 years before we're going to have the final proposal come to us so that we can maybe implement something. And yet here we sit here today like we argue on other things about the importance of what we mean to the state of Nebraska. And then we're arguing and slowing. We are part of the problem of slowing the process down to get where we need to get. And I don't know why we can't continue to do what some of the programs, Bosselman and Geis, Senator Bosselman, Senator Geis have worked very hard to get there. Senator Brandt has. We need to help get the federal funding. We need to help get this moving so that we can get broadband to the people of the state of Nebraska. Thank you very much.
Thank you, Senator Dorn. Senator Michaela Cavanaugh, you're recognized to speak.
Thank you, Mr. President. Sorry, colleagues, I was over speaking with my fellow committee members about this very bill. And we are talking through some of the concerns I have and trying to find some more path forward on this. So one of the things that we don't get Transportation Committee doesn't get a lot of floor time on things, and when we do, we kind of get to nerd out a little bit on things like the USF, Universal Service Fund, and the broadband, and the BEAD program, and so we're all huddling over there talking about all of this. So my concern is creating a new state agency, and if we are creating a new state agency, are we doing it with intention and purpose? And intention beyond just this one granting program. I am not opposed to creating a new state agency, but I don't want to do it accidentally because we felt like a grant program was more appropriate sitting with X instead of Y. I want it to be intentional because that is a really big thing to do. So I think we're going to continue talking about that and the intentionality behind that. We did talk about other ways to address concerns about this not being intentional to create a new state agency, discussing this now. This is a trigger, people, a sunset. Trigger warning, sunset. Discussing a sunset. And I threw that idea into the mix, and Senator Bosselman made a very excellent point that we are trying to hire high-level professionals to do this deployment of this funding, of this granting, and that's going to be a challenge if their job is on the line because of a sunset. And I take that point very seriously, and I think that is an excellent point. So sunset maybe isn't the right answer, but I do think that there is some way to move forward with purpose and intentionality in what this bill seeks to do and what this bill does. And I'm not sure that we are quite there yet. It is a complicated thing. I don't know, I'm like waiting for some unicameral historical guru to come tell me when the last time was that we created a state agency. I'm not sure who that is. Maybe I'll just telepath it out there. Tom Brewer's legal counsel. He seems like he might be the guy for the job to have some institutional knowledge on when we last created a state agency. But I think it would be good for us as a body to know that historical information. When was the last time that happened? What did that look like? What was the process and the steps involved in that? And what did the legislature do? What intentionality was put forward and intent into the statute in creating
1 minute.
that? So our Public Service Commission is in our Constitution. And so clearly a great deal of intentionality went into creating that. Common carrier is in our state constitution, but we have not maintained our state constitution to keep up with the technology of today. So there is a lot going on with this piece of legislation that is complicated and a little bit messy, but I'm grateful to my colleagues on the Transportation and Telecommunications Committee because I think that they are dedicated to get to all of the right answers in the right way So thank you, Mr. President, and I will yield the remainder of my time.
Thank you, Senator Kavanaugh. Senator Conrad, you're recognized to speak.
Thank you, Mr. President. Is this my third time? Did you keep track from this morning? I believe it is, but I just wanted to make sure.
You may use it as a close.
This is your second.
This is my second. Very good. Thank you so much, Mr. President. Appreciate it. Good afternoon, colleagues. Thank you for the opportunity to continue the dialogue on a very important issue. I think that we have clearly established that there's a great deal of consensus in terms of the overall goals when it comes to ensuring broadband access and equity for all of our communities, and in particular to ensure that we're closing those gaps in the digital divide for underserved communities, whether that's in urban areas or in rural areas as well. And I think we all recognize the importance of ensuring access to reliable broadband services for business purposes, for educational purposes, for telehealth purposes, for precision ag, for various and sundry key functions of government like registering to vote or interfacing with the courts. And, one thing that really caught my eye over the past year or so in terms of some of the issues that I try to learn about more and focus on in preparing for the legislative debate was the Nebraska Lawyer magazine had a kind of an article with an interactive map, and it's about sometime in one of their publications over the past year or so, which showed kind of the current state of affairs for ensuring access to reliable internet for courthouses across the state. And it was not a robust picture, which I think was disturbing, particularly as we're doing more and more online in the court system. So even in some of those key core functions of government, filing documents, ensuring access to the courts, et cetera, we're still seeing connectivity problems in many county courthouses across the state. So that really, I think, seeks to highlight the gravity of this acute need. So the other pieces that I just wanted to continue to add some dialogue and deliberation and pose a few questions around were kind of along the lines that Senator Dungan and Senator DeBoer were talking about in some of the appeal structures and processes that have been laid out for this new regulatory framework around some of our broadband policy and funding decisions. One thing that I did just want to note, because I think Senator DeBoer mentioned that the component which said that these appeals will take precedent over other cases that may be on the district court's docket, that really reminds me of very similar language that exists, say, for example, in our public records law, our open records law, which is meant to kind of give a special priority to open records cases that need to be filed to ensure the public's right to know is paramount and addressed effectively and efficiently. I do know, based on handling a fair amount of public records, open records cases over the course of my legal career, that even with that kind of priority approach in terms of docketing, that those cases can still take months and years to sort out. So I do just want to make sure that if the body is seeking for a swifter resolution of potential appeals, that we may need to look to other models or provide perhaps even more clarity about, thank you, Mr. President, our goals in regards to how those appeals are handled. The last couple pieces that I just wanted to continue the dialogue on were really surrounding kind of the role of the legislature and historically the power of the purse that belongs to the legislative body. And there is no doubt a significant amount of federal funds that are going to be flowing through these various programs that then will be allocated instead of at the PSC now through this new office or this new agency. And I I am a bit nervous about relinquishing the power of the purse to an executive branch agency, and would like to have additional dialogue and communication about maintaining the fidelity to our appropriations power and decision-making for these key issues moving forward.
That's your
I'll
time.
wrap it up there. Thank you, Mr. President.
Thank you, Senator Conrad. Senator Michaela Cavanaugh, you're recognized to speak. This is your last opportunity.
Thank you, Mr. President. I kind of lost track of what I was talking about. So, interesting question posed to me, difference between an agency, a department, and an office. I don't actually know. I don't know the answer to that. What is the difference between an agency, department, and an office? My understanding of this is that we're creating an office. I might have said agency or department, and I think then if I did, which I probably did, I misspoke. We're creating a new office outside of an agency, but within an agency. So for transcribers, I am using my hands a lot. This is really helpful for you. So we are creating an office that reports directly to the governor for a specific program that already exists with another elected entity. We're moving that program from the elected entity, which is the Public Service Commission, to the newly created office that reports to the governor, but uses or shares space with the Department of Transportation. Clear as mud, right? So the concern, my big concern, is what we're doing at the rate the speed with which we are doing it, and whether or not we should do it, need to do it, and can do it. So I think Senator Dorn, and I apologize, I missed some of your comments. I was talking to my committee colleagues. We talked about there is a timeline. The PSC has developed a timeline for the BEAD program, and they shared it with us, the committee, at the hearing. It is a very tight timeline as far as some very clear benchmarks that must be met for the federal government. And one of my concerns has been disrupting that timeline. I think, and I am happy to stand for correction, I think that if we did not do this now, if we allowed the Public Service Commission to move forward with the granting timeline as laid out in this document, that they submit the 5-year plan, that they do it in consultation with the Department of Transportation, that we let things continue to move forward the way that they are, I think that we could work to have a more purposeful resolution to where this program should sit. So maybe we can do that. Maybe we can't. I appreciate that others feel that this is an urgency that needs to happen now. I have a differing view on that. I think that it is something that we could do after those benchmark things of the strategic plan are put forward. I think that it could be potentially disruptive to the process to make that change now while we are in the middle of the process. I think we've already hired some of the people, and that the intention appears to be to move the individuals who have been hired for the PSC over to
1 minute.
the new office. But making this substantive change in where the program sits in the middle of a massive federal granting process that's only a couple of months away feels unnecessary at the time. I would prefer to see it stay where it is. We work together to figure out where it should be, and then move in that direction with intentionality. Thank you, Mr. President.
Thank you, Senator Kavanaugh. Senator Conrad, you're recognized to close on the bracket motion.
Thank you, Mr. President. I'll withdraw the motion.
The motion is withdrawn. Mr. Clerk, for items.
Thank you, Mr. President. Quickly, some items. Motions to be printed. Senator Hunt to LB 262, 267, 276, Senator Michaela Kavanaugh to LB 277. Additionally, your Committee on Enrollment Review reports Legislative Bill 376 is correctly engrossed and placed on final reading. Mr. President, next item on Legislative Bill 683. I have an understanding that the next item up will be the committee amendments. Senator Geist, Chair of Transportation Committee.
Senator Geist, you're recognized to open on AM 870.
Thank you, Mr. President. And I actually did read this earlier, but I'm going to read it again. I'll refresh your memory on what the amendment is. And if you have any questions, I'm happy to take those. I think we've talked about this quite a bit, but I'm happy to take any questions should anyone decide they have some. The explanation of the amendment AM 870 is the committee amendment clarifies a couple of items related to the organization of the State Broadband Office. For administrative purposes, the Broadband Office will be located within the Department of Transportation. Language is incorporated that directs DOT to provide office space, supplies, and other necessary support to allow the Broadband Office to function. Additionally, the DOT will provide administrative and budget support to the office. The installation, operation, and maintenance of projects shall not be funded by the DOT except for those specifically designed to meet the state's needs on the state highway system. DOT is not authorized to own, operate, manage, construct, or maintain fiber optic, broadband, or similar technologies outside of the state highway property. The committee amendment adds a new section that provides that the director of broadband shall report to the legislature on December 1st of each year on the status of the office and the efforts to deploy broadband, engage in community outreach, and detail any changes to the state strategic plan. The Transportation and Telecommunications Committee is directed to conduct a public hearing following the receipt of the report. The language is also added that provides if any final decision of the Broadband Office relating to the funding for projects is appealed, and I believe this is the section that Senator DeBoer was referencing when she was talking about the appeals process, and that is the language that she was referencing. And finally, the committee amendment amends Section 86-1309, which currently provides that the Public Service Commission shall administer the Nebraska Broadband Bridge Act and federal funds received for broadband enhancement purposes. The section is amended to provide that the PSC shall administer the Broadband Bridge Act and any federal broadband enhancement funds that are designated by the governor. And again, I want to highlight that the intent of 683 and the committee is that the Public Service Commission will continue to administer the universal service funds, which I spoke to earlier. That will not change. And those charges against your voice portion of your phone bills, those are surcharges. I incorrectly referenced those. But those are the surcharges that go on your phone bill against the voice part of your bill. Anyway, they will continue to administer those funds, the Broadband Bridge Act and Federal Capital Projects Fund program. Only the responsibility for the Broadband Equity, Access, and Deployment Program, or BEAD, will transfer to the Nebraska Broadband Office and the Director of Broadband. Upon passage, this bill will require the governor to apply to the federal administrator of the BEAD program, the National Telecommunications and Information Administration, to seek a change in the state administrative agency from the Public Service Commission to the State Broadband Office. And that includes the introduction, Mr. President, and I'm happy to answer any questions that the body may continue to have on this issue. Thank you very much, Mr. President.
Thank you, Senator Guy. Senator Frederickson has some guests in the north balcony. They're fourth graders from Rockbrook Elementary in Omaha, and their teacher, Michelle Madsen, is retiring at the end of the year. Please stand and be recognized by your Nebraska Legislature. Mr. Clerk, for an amendment.
Mr. President, Senator Michaela Cavanaugh would move to amend the committee amendments with AM 1083.
Senator Michaela Cavanaugh, you're recognized to open on AM 1083.
Thank you, Mr. President. I am getting through to my, okay, so this is on the committee amendment. So page 8, line 30. So it strikes the matter, which is designated by the governor, and reinstates the stricken matter. So what this amendment would do is, it currently reads, the committee amendment currently reads, the Nebraska Broadband Bridge Fund is created. The fund shall consist of money appropriated by the legislature and federal funds, the new language, designated by the governor for broadband enhancement purposes. What it would be reinstating is appropriated by the legislature and federal funds received for broadband enhancement purposes. This is a very important change. For those of you who were not here in 2020, this is going to be a little history lesson. In 2020, we took a hiatus during session in March when everything shut down because of the pandemic, and we adjourned for several months, and we came back in the end of July, last week of July, first week of August. During that time, we received massive amounts of federal money because of a stipulation that we put in our budget. The governor had carte blanche authority over those funds. Now, we could have chosen to come back and allocate those funds, which I did advocate for with some of my colleagues at the time, but we did not. The governor did not spend a lot of the funds. He spent some of the funds in a way that was upsetting to several members of the body. He spent broadband funds in a way that really upset members of the Telecommunications Committee at that time. And he did it with complete discretion and no oversight from the legislature. Our job is oversight of the dollars spent in this state. So, what I am attempting to do in this amendment is to strike giving the governor complete authority over the federal funds, reinstating how it is currently done. Even if we create a new agency or department or office, whatever we create, we never create it and give the governor complete control over how the money is spent. This would be circumventing our entire appropriations process. I don't know why we would do that. So what this amendment does is takes out giving the governor carte blanche authority on how these dollars are spent and maintains how we currently do this process. If we are going to move this money and this program out of the Public Service Commission and under the governor, we don't give the PSC that authority. Why would we give the governor that authority? Why would we give away our own authority? So that's what this amendment does. I hope that members of this body will give it their consideration, because I believe that this is a very bad precedence to set. Thank you, Mr. President.
Thank you, Senator Kavanaugh. Senator Halloran, you're recognized to speak.
Thank you, Mr. President. Good afternoon, colleagues. There's no question in my mind that we need to have a state broadband coordinator. I believe that's necessary. I think it's evident in the fact that we don't have broadband coverage. My concern is, and I think it's negligence on our part, that we haven't recognized that public service has inadequate staffing to do it. My suggestion would be is that we appropriate some funds to public service to be able to hire a state broadband coordinator and staffing necessary to facilitate his role as spelled out in the bill, to be able to do that, but under the jurisdiction of public service. Public service is an elected position, subject to the public and to a vote. It's not a political office, but it's responsible to the electorate. And I have some anxiety about setting up a new department. Should be under public service. And I believe that if we hired someone, appropriated funds to public service to be able to employ or engage a state broadband coordinator to fulfill everything that's spelled out in this bill, I think that might be a better alternative than what we're looking at today. Something for consideration. Not too many people are here, so this is falling on not deaf ears, but not many ears. But I think it's something to consider. The goal could be the same, the results can be the same, but it would still be under the Public Service Commission. Thank you, Mr. President.
Thank you, Senator Halloran. Senator Hunt, you're recognized to speak.
Thank you, Mr. Lieutenant Governor. Good afternoon, colleagues. Good afternoon, Nebraskans. I often go to my office to listen because when I'm on the floor, I get a little bit distracted and I actually have a harder time hearing what people are saying than if I'm in my office watching on the monitor. And then, you know, I not only can focus on what's being said, but I can see the speaker very easily too on the screen. And I don't know if it's because of the pandemic or aging or a combination or different things, but my attention span has really become shot. And so being able to do that is one of my favorite ways to listen to debate. So I don't think we should worry too much that it's falling on deaf ears, because I do think people are listening to what we're saying and paying some attention. At least I was for this afternoon up until this point. I also agree with Senator Halloran, who, in terms of what he said about maybe we need to appropriate some more funds to the PSC. My heartburn that I have about the new office that's been created is I am concerned about wasteful spending. I'm concerned that when we see a Republican governor do it, we trust his judgment and we think this must be judicious. When, you know, a progressive wants to spend money, we think they must be wasting government funds. But I am not convinced that this isn't going to be duplicative or redundant in some way. And I'm also not convinced that it's going to end up in a cost savings for Nebraskans. The Department of Transportation will have to provide new office space, new equipment, new staff, and the Public Service Commission already has this space, but could probably use more staff and could probably use more resources. And this is sort of consistent with a problem we see a lot in government, which is we see one agency or institution, whether that's a prison or a hospital or a school or, gosh, I guess those are the three things government does, aren't they? Educate, medicate, incarcerate. But we see problems in those institutions, and then we think the solution is either to privatize it or to start a new one that's going to be more efficient instead of just kind of fixing what we have. And so that is the basis of my initial thoughts on it. And then digging more into the issue, I'm also not convinced that the Department of Transportation is the correct place for this. there's a constitutional mandate that gives the Public Service Commission the jurisdiction of common carriers. So that's telephones, of course, and when the PSC was created, that was for phones and things like that, but it's also for broadband services now. And I'm also concerned that the Department of Transportation perhaps lacks the level of technical expertise that the staff of the Public Service Commission has. We're talking about people who need experience with broadband deployment, tasking them with a really, really expensive task. For the first time in a new agency, I don't know if I believe that that's going to be the most judicious use of funds. I also look at what has happened in Nebraska in the past. Over the last several years, I've introduced bills in the government committee to require constitutional officers to go through
1 minute.
Thank you, Mr. President, to go through a bidding process for contracts, just like agencies and departments have to. And the reason for this was several years ago, Treasurer John Moranti opened an office in Omaha that seems like there was never any bids done on where the office was going to be. There was no sign on the office. It wasn't really accessible to the public. And there were a lot of questions about why this office was even open. You know, who's working here? What are the hours? Why don't you have a sign? Why can't the public come in here and receive services from the treasurer's office? And what it looked like on its face was that the treasurer used state funds to rent this office as a favor to a friend. And that's the kind of thing we want to avoid, and the kind of thing that would be avoided with the oversight that goes with an elected body like the Public Service Commission. Thank you, Mr. President.
Thank you, Senator Hunt. Senator Michaela Cavanaugh, you're recognized to speak.
Thank you, Mr. President. Colleagues, I have an opinion from 1989 on whether the protocol office would be an executive office of the state. For those who weren't listening before, this was a conversation around what is an office versus a department versus an agency. So this is to then Senator Scott Moore. I think a lot of people in this body know Scott Moore, serving Legislative District 24. So it says, you have inquired whether the protocol office, which LB 177 proposes to create, would be an executive office pursuant to Article 4, Section 27 of the Constitution of the State of Nebraska. And would thus require a 2/3 majority vote for creation. It is our determination that the proposed protocol office would not be an executive office as intended by the above referenced section of the state constitution. The Nebraska Supreme Court on several occasions have addressed the issue of what constitutes an executive office as intended in Article 4, Section 27 of the Constitution of the State of Nebraska in State versus Marsh. 146, Nebraska 750, 21, end of that period, W period 2D, 503 parentheses 1946. The Nebraska Supreme Court found the Department of Agriculture was an executive department within the meaning of the state constitution. The court determined in Marsh that an executive office is one, the duties of which are mainly to cause the laws to be executed. The court cited several laws which the Department of Agriculture had the power and duty to enforce. Okay, so the court determined that Nebraska, in the State versus Chase in 1946, the court determined that the Nebraska Liquor Commission was not an executive office since it was not charged with the actual execution and enforcement of laws. The court said a very important test is that the department, if executed, it has primarily to do with the political government of the state in the execution and enforcement of the law, wherein the governor is the supreme executive head. In Makota versus State Board of Equalization and Assessment in 1945, the court held that the Department of Industrial Development had been defectively established in that it had not received the requisite 2/3 majority required to establish a new executive department. In so holding, the court cited to State versus Lochner in State versus Lochner supra, the following appears. Ministerial offices, it is said, are those which give the officer no power to judge of the matter to be done and which require him to obey some superior. An executive officer, in the proper sense of the term, is one whose duties are mainly to cause the laws to be executed, such as the president, the governor of the state, or the chief executive officer of a city. It pertains to the execution and enforcement of laws by one charged with a particular duty. Further, in Somerville versus Johnson, the Supreme Court held that the agency cited by the Merit System Act was not an executive office. The reading of the opinion,
1 minute.
thank you, in that case demonstrates that the court was influenced in reaching its conclusion by the fact that the Merit System organization was not vested with authority to administer or enforce any laws other than the law by which the agency was created. The following language appears in the opinion. I'll stop there. I just want to have a conversation about if we're doing what we're doing, how we're doing it, making sure that we are doing it in the appropriate manner set forth in our own laws and Constitution. Thank you, Mr. President.
Thank you, Senator Kavanaugh. Senator Hunt, you are recognized to speak.
Thank you, Mr. President. I have introduced some amendments to LB 683 that a couple of them address some of the problems that I was talking about regarding the accountability that I think this office needs to have. One of the amendments I introduced is AM 1073, which would require the broadband office to maintain a satellite office in each congressional district to ensure all Nebraska residents can access the office's services, especially if they don't have access to broadband in Western Nebraska. This would make a lot of sense for people, especially if they don't have reliable internet, that they should be within a reasonable drive of an office that can serve them. And talking more about just the increased oversight and accountability we need to have for not agencies, but yes, agencies, but particularly ones created by state constitutional officers. Talking more about what happened with Treasurer Moranti that I don't think was ever resolved or it was kind of one of those news items that everyone is talking about and then it blows over and then a couple years later you're like, what became of that? It's kind of like the caravan, right, guys? That's my touchstone on that is everybody was so worried about the caravan and then nothing happened with that. Now nobody talks about it now that the election's over. But State Treasurer John Moranti opened a West Omaha office in 2019 and called it part of his public outreach efforts, but there was very little that was made publicly known about that office. It wasn't listed on the state treasurer's website. There was no press release about it. There's no signage outside the office to indicate that there's a state office building or a state office inside. There wasn't even a mention that the state treasurer had an office there in the little directory that was next to the elevator in the building. So no member of the public could have reasonably believed that there was a office of the treasurer in that building. And reporting from the Omaha World Herald said, it's only after you take the elevator to floor 2 and wander down a quiet hallway that you'll find a glass door with a copy machine printed sign taped to it proclaiming that it's a state treasurer's office. The office, which has been open at that time for 4 months, is raising eyebrows among some who watch government spending and transparency. The office costs $58,700 a year and was leased for 10 years. So State Treasurer Moranti, who, is he going to be in office for 10 years? He leases an office for 10 years, $58,700 a year. The people of Nebraska should ask, who's benefiting from that contract of this building that has no sign, that has no indication inside the building that there's a treasurer's office there, that has a copy machine paper sign taped to the door? Who's working there, and why does it cost taxpayers $58,700 a year? It says the discovery of the office comes as questions are being raised about a spate of recent television ads run by the first-term treasurer that prominently feature Moranti and his family. Those ads have cost nearly $600,000 over the past 6 months and were produced by a company for which Moranti had worked. That company was called Victory Enterprises, and this isn't a company that typically works on public service announcements that are meant for public consumption and public information. Victory Enterprises is a political consulting firm, and it's one that Treasurer Moranti had previously worked for and hired. And some documents that were found by Common Cause Nebraska had listed him as a director of Victory Enterprises in the past. And this is also the same agency that he hired to handle his campaign for his 2018 election to state treasurer that had just recently put him in office, and presumably working on his future campaigns as well. And I think we can all
That's
see—
your time, Senator.
Thank you, Mr. President.
Thank you, Senator Hunt. Senator Day, you're recognized to speak.
Thank you, Mr. President. I yield my time to Senator Michaela Cavanaugh.
Senator Kavanaugh, you have 4 minutes, 45 seconds.
Thank you, Mr. President. Thank you, Senator Day. I'm going to finish reading this part of the Attorney AG's opinion from 1989. Okay, and then I have conversation around it. So the following language appears in the opinion. Asterisk 2, it is evident that the legislature here established an agency in the nature of a civil service commission. It created a council to guide and direct the administration of the act. ... It is intended to promote efficiency, economy, and equality. ... In the participating agencies. It depends in part upon cooperative effort between the council, the director, and the participating agencies. It administers no law save the law by which it was created. ... It executes none of the laws of the state so far as they relate to the people generally. We think it is quite clear that it does not create an executive department nor an executive state office within the meaning of constitutional provisions herein discussed. In each of the Supreme Court decisions mentioned above, it appears that one common controlling factor upon which the court relied in reaching its conclusion was whether or not the agency in question was empowered to administer and enforce pertinent general laws of the state. It appears from a reading of LB 177 that the protocol office is intended to function in coordination or liaison capacity. The office is given no power to enforce the general laws of the state, nor even the power to promulgate rules and regulations. It is clear from the reading of LB 177 as introduced that the protocol office would not be an executive office as contemplated by Article 4, Section 27 of the state constitution. Therefore, a simple majority of the vote would be sufficient to create the office. So, I share that because we do want to make sure that if we are creating an executive, let me find the right words, a new executive department, if that's what we're doing, we need 2/3 majority. If that's not what we're doing, we need a simple majority. So I think we're still a little unclear as to if that is what we are doing or not. I think that it is not the intent of the governor to create a new executive department, but going to his executive order. Okay, so the broadband coordinator, Governor of State of Nebraska, pursuant to the authority vested in me as governor by the Constitution, hereby establish the office of the broadband coordinator. The broadband coordinator function will operate under the guidance and direction of the Nebraska Department of Transportation and the office of the governor, and will operate with the following purposes and charges. Provide for policy level direction related to planning decisions regarding development, operation, sustainability, high-speed broadband service in the state of Nebraska. It goes on. So that doesn't, see, this is when probably having a law degree would come in handy. These are the nuances of the language that I'm not quite sure if this does create a new executive office or if this doesn't create a new executive office. So I'm certain that this piece of legislation has the votes that it needs to meet that 2/3 threshold. However, even if it has those votes, I think it would behoove us as a body to have an answer as to what it is we are actually doing and what it is we are creating. So we will continue on this conversation. I think that I am next in the queue. So I'd like to switch, and I'm sure I'll run out of time and then start up in my next time. I would like to switch.
Senator, this, so you know, this is your third time, and then you'll have your close.
Thank you, Mr. President. Okay, so I'm trying to figure out, this is taking us back to the amendment at hand. AM 1083 strikes the designated by the governor language. The full sentence is, the funds shall consist of money appropriated by the legislature and federal funds designated by the governor. It reinstates, and federal funds received for broadband enhancement purposes. So I'm trying to find out where this was in the original bill, the designated by the governor, because I don't see it in the original bill. I see it in the amendment, but not in the underlying bill. And I'm very, very concerned about the layers we are taking away of transparency, oversight, good governance. And I think that this particular amendment reinstates some of that oversight and authority that we ourselves have. It's really important that we not just give away our authority. When we give it away, it makes it easier to give it away in the future until we no longer have any authority. I appreciate Senator Steve Halloran and Senator Steve Erdman's comments on this. I think it's fun to keep the people on their toes as to when Senator Michaela Cavanaugh and Senator Halloran and Erdman will be on the same side of an issue. It happens. This is big. This is a big deal. This is a big project. This is a big undertaking. So I hope we can be thoughtful about it. And I'm going to continue to look and see. I really don't see in the original bill where we give the governor authority over the money as we do in the amendment. And I apologize to my committee members if I missed that change, because I think that that is a substantial change, a very substantial change. And I find it to be a concerning change as to why we would make it that way. We didn't give the PSC that authority when we created the BEAD program. So I do have pretty significant concerns over that. I hope when we do get to a vote on AM 1083, that colleagues, you will consider supporting striking that language from the underlying committee amendment. I'm still trying, I'm just not understanding that change. I see ensure on the original bill, page 3 of the original bill, line 2, it ensures all government funding is utilized in a cost-efficient and accountable manner for Nebraska broadband projects. That's kind of underneath what the Nebraska Broadband Office shall.
1 minute.
Their duties as prescribed, but it doesn't say anything about the funds and the governor's discretion over the funds. So it does say on the original bill on page 2, line 12, all administrative and budgetary decisions for the Nebraska Broadband Office shall be made by the Director of Broadband. Again, and maybe I am missing it. There's a lot of underlined and crossed out lines here, so I could very well be missing it in the original bill. I don't see it, and it does cause me concern to give the governor that authority and really abdicate our own authority. So thank you, Mr. President.
Thank you, Senator Kavanaugh. Senator Hunt, you're recognized to speak, and this is your third opportunity.
Thank you, Mr. President. Finishing my thoughts about the treasurer's office, which I was bringing up to exemplify the concerns I have about the power we give to constitutional offices without giving them any oversight. And the reason why I think that we should trust an elected board, the Public Service Commission, instead of creating a new office under the executive branch. I talked about part of the news story and part of the reporting that happened around Senator Morante's spending, or Treasurer Morante's spending on an office in West Omaha. The office is costing $58,700 a year and is leased for 10 years. Looks like this began in 2019. So let me see. So this lease will be up in 2029. And in that time, it will have cost taxpayers $587,000 just in rent. Just in rent. And what are they doing in this office? Well, as the reporting says, the office is meant to be part of Treasurer Morante's public outreach efforts, but there's almost nothing public about the office. The office doesn't have a sign. There's no mention of the office in the list of tenants by the building's elevator. There's no signage outside the office to indicate that there's a state office inside at all. It's not listed on the state treasurer's website. There'd been no press release about it. So that's over $500,000, $587,000 just for rent that taxpayers are on the hook for this strip mall office, basically, that Treasurer Moranti rented. And it begs the question, who owns this strip mall? Who got this nearly $600,000 contract from the taxpayers so that Treasurer Moranti could basically have an empty office? Sounds like a good deal to me. I think maybe I made a mistake brushing off some conservative Republicans because it sounds like they're getting the best deals out of government here in this state. And when I read news like this, you don't love it. It makes you want to change the law. It makes you want to put that accountability back into statute to find a way to make sure that the way we steward these taxpayer dollars is done with responsibility. And that's what I did for last 3 years in a row, I believe. This year I introduced LB 485 to require constitutional officers, which would include people in the executive branch of government. So the governor, the lieutenant governor, secretary of state, auditor of public accounts, state treasurer, and attorney general. It would require them to get bids for contracts, which probably would have prevented this problem with the treasurer's office. And of course, the treasurer's office has a legitimate reason to use advertising, and that's to inform people of the services they provide, the services they manage, like the state's college savings plans, of course, the unclaimed property that the state treasurer's office manages. And the need for this bill, to say nothing of this empty $600,000 office that the taxpayers are paying for, the need for it came to my attention originally in 2019 when a constituent reached out to me regarding ads. Thank you, Mr. President. Regarding ads he was seeing on TV from the state treasurer's office that looked like campaign ads. They had his name really bold. It didn't say Office of the Treasurer. It said John Moranti. You know, it feels like a campaign ad. It didn't have, you know, here's me at my calculator doing treasuring. Like, no, it was his family, like a smiling picture of his family. Feels just like a campaign ad. So many people reached out to me about that ad. And then this article from the Omaha World Herald came out, which shed light on some other questionable decisions. And it just made me think, there's a fix for this. And one of the things that we can do to fix this is just make sure that we are requiring state constitutional officers to get bids for their contracts, just like every other agency has to do. Thank you, Mr. President.
She said. Thank you, Senator. Senator Day, you're recognized to speak.
Thank you, Mr. President, and I yield my time to Senator Michaela Cavanaugh.
4 minutes and 53 seconds.
Thank you, Mr. President. Thank you, Senator Day. Okay, so few issues. We are creating a new entity, unclear if it is an agency, a department, or an office. It seems to be an office, but what does that mean? In the AG's opinion from 1989, when we establish an executive department, as defined in that AG's opinion, we must have 2/3 vote. Are we establishing an executive department with LB 683? What are we establishing? What are the long-term goals of what we're establishing, or are they only this one particular program? The program is the BEAD program, which is the Broadband Equity, Access, and Deployment Program. This is a program that is federally funded, is short-term, and currently sits with the Public Service Commission. So we are moving the BEAD program from the Public Service Commission and putting it into a new office, broadband office. The issue for me is not a broadband office. I think we probably need a broadband office. I don't think that we should do it without a plan and thoughtfulness, because like most things, it is very hard to undo once we do it. It is unclear if the governor intended to create a permanent office, or if he intended to just move this one singular program from one entity to a new entity. So, the amendment that I am currently discussing, AM 1083, strikes the language on page 8 of the committee amendment that says that the federal funds designated by the governor, and then reinstates federal funds received for broadband enhancement purposes. So, what I am seeking to do with this specific amendment is to not take away our own authority, to not water down our appropriations process, to not take away our oversight ability. We are already giving the governor,
1 minute.
in doing this, we are giving the governor a larger purview over some of the functions of the government, because we are taking a function away from a different elected body and giving it to the governor. That causes me a great deal of hesitation. The argument has been made that this is a new program, that the PSC isn't doing it fast enough, that the Department of Transportation can do it better and faster. Those things might be true. But we could give the PSC the funding that they need to ensure that they can do the program the way that it needs to be done, at the speed that it needs to be done. We can get the PSC and the department working closer
That's your
together.
time, Senator. Thank you, Senator Kavanaugh. Senator Day, you're recognized to speak, and this is your third opportunity.
Thank you, Mr. President. I yield my time to Senator Michaela Kavanaugh.
Senator Michaela Kavanaugh, you have 4 minutes, 55 seconds.
Thank you, Mr. President. Thank you, Senator Day. So, we have a choice to make here on this broader bill. But right now, I am asking that we just consider how broadly we are giving power to the governor. And if we are going to give the governor this ability, if we are going to give the governor this federal program, if we are going to take it away from another elected body, do we need to make it this expansive? We can always make it more expansive if necessary. But right now, for a starting point, to make a program, we're already expanding the governor's authority if we enact this bill purely on the program basis. If we keep this language that I am trying to strike in the bill, we further expand the governor's authority. And I am not comfortable with us as a body giving away our authority in the appropriations process. And it might just seem like a little thing, but these drips of water are starting to fill a bucket up. We are eroding our own authority, and we are giving it to the governor. And I don't think that that is a responsible thing for us to be doing. We are giving away our appropriation power, our power over being good stewards of taxpayer dollars, whether they are federal or state. It is still our job and our authority. And I don't think we should give that away in any instance without some serious contemplation. AM 870 adds in language that allows the governor to designate the federal funds for broadband purposes. There are some additional concerns around giving money to the governor for federal purposes around broadband. And these concerns are not directed at this specific governor, because I have no reason to think this. This is not based on anything. This is a broader issue. The PSC, elected members of the PSC, cannot have another job. They cannot have another job because of the concern of conflicts of interest, undue influence, etc. That is purposeful because they are dealing with some very important things. So there is some very clear guidelines around the financial propriety of the PSC. We are taking this federal program away from this elected body that has these very clear stipulations around how they are to function in this space, financially, personally, and giving it to the governor's office. That doesn't have that. That is not appropriate. We are continuing to diminish the integrity and transparency and the oversight around the program and the tax dollars. So if we are going to do this, let's do this with some of these guardrails in place. This wasn't in the original bill. This wasn't part of the hearing. The public didn't have the opportunity to come in and say if they support this or not. I don't think we should include it at this stage.
That's your time, Senator, and you're recognized to close.
Thank you, Mr. President. I'd like a call of the House.
There's a request to place the House under call. The question is, shall the House be under call? All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
6 days, 2 nays, place the House under call.
The House is under call. Senators, please record your presence. Those unexcused senators outside the chamber, please return to the chamber and record your presence. All unauthorized personnel, please leave the floor. The House is under call. Senator Michaela Cavanaugh, you're recognized to continue your close. You have 4 minutes, 42 seconds.
Thank you, Mr. President. Colleagues, I'm sorry to disrupt all your conversations, but I did want people to be present while I explained the amendment that you're voting on. So AM 1083 strikes from page 8 of the amendment, line 30, designated by the governor, and it reinstates the original language that says the fund shall consist of money appropriated by the legislature and federal funds received for broadband enhancement purposes. The intention here is if we are going to take this program away from the elected Public Service Commission and move it into the office of the governor, that we don't also add additional discretionary ability to the governor to use the federal funds without oversight. My intention here is to maintain our appropriations process, to maintain the integrity of the legislature and our role in oversight and our role in being good stewards of the taxpayer dollars. And so I hope that the body will consider voting for AM 1083 that strikes that language designated by the governor and just keeps it as that language was added in the committee amendment. It wasn't in the original bill. So I would like to keep the language out of the committee amendment. Thank you, Mr. President.
Thank you, Senator Kavanaugh. Senators Conrad, let's see, Armendariz is there, Vargas, Dover, McDonald, Clemens, and Wayne, please return to the chamber. The House is under call. Senators Clemens, Wayne, and McDonald, please return to the chamber. The House is under call. All unexcused members are now present. The question is the adoption of AM 1083. There's been a request for roll call vote. Mr. Clerk.
Senator Aguilar, Senator Albright, voting no. Senator Arch, voting no. Senator Armendariz, voting no. Senator Ballard, voting no. Senator Blood, Senator Bostar, not voting. Senator Bostelman, voting no. Senator Brandt, voting no. Senator Brewer, voting no. Senator Breezy, voting no. Senator John Kavanaugh, not voting. Senator Michaela Kavanaugh, voting yes. Senator Clements, voting no. Senator Conrad, voting yes. Senator Day, voting yes. Senator DeBoer, not voting. Senator DeKay, Voting no, Senator Dorn. Voting no, Senator Dover. Voting no, Senator Dungan. Not voting, Senator Erdman. Voting no, Senator Frederickson. Not voting, Senator Geist. Voting no, Senator Holleran. Voting no, Senator Hansen. Voting no, Senator Hardin. Voting no, Senator Holdcroft. Voting no, Senator Hughes. Voting no, Senator Hunt. Voting yes, Senator Ibach. Voting no, Senator Jacobson. Voting no, Senator Kauth. Voting no, Senator Linehan. Voting no, Senator Lippincott. Voting no, Senator Lowe. Voting no, Senator McDonald. Voting no, Senator McKinney. Senator Mosier. Voting no, Senator Merman. Voting no, Senator Raybold. Voting yes, Senator Reapy. Voting no, Senator Sanders. Voting no, Senator Slama. Senator Vargas. Voting no, Senator Von Gillern. Voting no, Senator Walls. Not voting, Senator Wayne. Voting yes, Senator Wishart. Vote is 6 ayes, 32 nays, Mr. President, on adoption of the amendment.
The amendment is not adopted. I raise the call. Mr. Clerk.
Mr. President, some items. Motions to be printed, Senator Hunt to LB 286, Senator Michaela Cavanaugh to LB 294, Senator Hunt to LB 286, Senator Michaela Cavanaugh to LB 294, Senator Hunt to LB 296, 297, Senator Hunt 298, Senator Michaela Cavanaugh 307 and 308, 314. Additionally, new LR 78 from Senator McDonald. That'll be laid over. Mr. President, the next item on LB 683 in the committee amendments. Senator Michaela Cavanaugh would move to amend the committee amendments with AM 1094.
Senator Michaela Cavanaugh, you're recognized to open on AM 1094.
Thank you, Mr. President. Colleagues, I'm actually genuinely disappointed in that last vote. I really thought more of you would have not given away $240 million with no discretion to the governor. That stung. That stung a lot. I wouldn't have done a call of a house if I thought that the vote was going to be that lopsided, because I genuinely thought people would want to vote to maintain our own power and authority. I especially thought that the senators that were in opposition to expansion of government, that stood up and spoke on that, would have supported that. That didn't have a hearing, that wasn't part of the hearing. Where literally all of the Appropriations Committee members voted against that. Why are you on the Appropriations Committee? If you're just willing to give away $240 million, you don't need to do your job. I get it. It's me. I understand the irritation and the inclination to not listen to me, but you should still do your job. And that vote, to me, was a failure of this body. Thank you to the handful of people that voted for it. I appreciate that. This bill is a really big deal. This is a really big deal, and people are not engaging in the conversation. People are not listening to the conversation. And then you're just hitting your red button because it's me. You are giving away our own authority to oversee $240 million. That is what you just did. Why? Because I introduced the amendment? I love public policy. I love good, strong public policy. I love working on public policy. I love working to make things better. I believe in process. I believe in transparency. I believe in oversight. I don't like government waste. I don't like overspending. I don't like bloated government. I have a lot in common with a lot of you if you ever stop to listen to the things that I say. I do not believe that it is appropriate for our legislature to abdicate our authority. This isn't a state of emergency. We just abdicated our authority over $240 million. It didn't have a hearing. It wasn't part of the underlying bill. It was put in the amendment. I spent over an hour talking about it. Okay. So now we're on to the next. AM 1094. My papers have gotten a little out of order here. Let's see here, AM 1094. Okay, page 4, line 15 of the amendment. Get to that. Page 4, line 15. Strikes. Serve at the pleasure of. The director shall be appointed and serve at the pleasure of the governor. This one, I understand why you would vote against it. This one is a filibuster delay tactic. This one, I'll spend my time talking on, and we'll go to the next. And we'll go to the next. And depending on just trying to take more time and not have to talk as much, I might do a call to the House on it. But I certainly have lost a lot of respect. I've lost a lot of respect on that last vote. A lot. A lot. So, AM 1094 strikes at the pleasure of the Nebraska. So the amendment says, it is the intent of the legislature to ensure that all federal, state, and local government funding for broadband infrastructure and services in Nebraska be leveraged strategically to ensure that all Nebraskans have access to affordable, reliable broadband services before January 1, 2028. To accomplish this intent, the Nebraska Broadband Office is created. The office shall be headed by the Director of Broadband. The director shall be appointed and serve at the pleasure of the governor, with the approval of the majority of the legislature. For administrative and budgetary purposes, the Nebraska Broadband Office shall be located in the Department of Transportation. All administrative and budgetary decisions for the Nebraska Broadband Office shall be made by the Director of Broadband. So this strikes at the pleasure of the governor, which I think goes back to the broader question of what are we creating? How many votes do we need to create it? Is it constitutional? Is it not constitutional? Constitutionality is a whole nother question. Pretty sure I keep getting a little cough. So we'll just work our way through these amendments. So looking at, how much time do I have?
2 minutes 15.
Thank you. Looking at the Nebraska Constitution, 4-20 Public Service Commission memberships, terms, powers. It's probably what I'm going to be discussing next, talking about what their power and authority is. Maybe the kids that are coming here for their school trips are learning something. Certainly my colleagues are not today. So it says on this document, absent a supermajority concurrence, the Nebraska Supreme Court could not invalidate a statute giving the governor authority to approve an interstate oil pipeline carrier's proposed route through the state and bestow upon the carrier the power to exercise eminent domain, despite the majority's conclusion that the legislation is facially unconstitutional. I am definitely mispronouncing that, because it transfers the Public Service Commission's constitutional powers
1 minute.
over common carriers to the governor. This is Thompson versus Heineman, 289 Nebraska 798, 857 NW 2D 731 in 2015. So their conversation moving forward is going to be around the constitutionality of divesting the Public Service Commission of jurisdiction over the BEAD program and giving it to the governor's office. Not that that's really going to matter to anyone in the body, but still going to talk about it. Thank you.
Senator Hunt, you're recognized to speak.
Thank you, Mr. President. First, colleagues and foremost Nebraskans, I have to cop to something really embarrassing that happened on my last time on the mic. I got out my calculator to multiply a large number by 10. And my staff was roasting me for that and going, Megan, you just put a 0 on the end. And I was like, yeah, I obviously know that. And I always say when I talk to groups of young kids in school or out in the rotunda, or when I go visit different groups who ask me questions, the number one question I get always is, what do you say to people to encourage them who are thinking about running for office? And I always say, you do not have to be a genius to get elected. It is not Jefferson and Lincoln down here. All you have to do is watch the Nebraska Legislature for half an hour and your imposter syndrome will melt away. You'll see you might say to yourself, well, I can at least do that. And that was a big part of my decision to run in 2017, was watching what we do down here. It was listening to a debate about licensure for horse massage. And I thought, girl, you can at least do that. You are not dumber than that. So that's all for someone who had to get the calculator out to multiply something by 10. So not great. You do not have to be a genius. And I encourage you to pursue your dreams, because once you reach your goals, you're going to find out you are not going to be the dumbest one. So I was talking about these ads on TV that were paid for by taxpayer dollars. They cost nearly $600,000 of taxpayer money. These ads that Treasurer Moranti had been running on TV to promote the office of the treasurer. And these ads, the problem with them was that they looked a lot like campaign ads and not public service announcements that they were meant to be about the types of services that the treasurer's office provides, like college savings accounts in the state or unclaimed property. And not only that, not only did these ads cost $600,000 that had, the splashy John Moranti, state treasurer, pictures of him with his smiling family, not really feeling like it's about the services in the office, but more about him as a candidate, cost $600,000 that we all paid for as taxpayers. And not only that, but the company which he hired to produce and place the ads, Victory Enterprises, was one that he used to work for. And it's a company that did his campaign ads when he was running. There was no competitive bidding process that was followed in the selection of this vendor, of Victory Enterprises. And in a bill that I introduced this year, LB 485, and I think this is the third year that I've introduced this type of idea, we're dealing with this competitive bidding problem. And that's what I think is at the heart of related to some of my opposition to LB 683. So on these advertisements in this agency, Victory Enterprises is not a company that typically works on public service announcements. It's a political consulting firm. It's one that Treasurer Moranti previously worked for, and it's one that he was formally listed as a director on in the past. And it's the same one he hired to manage his own campaign in 2018 that had just recently put him into office when these ads were running. So we can see how this is really messy from a lot of different angles.
1 minute.
Thank you, Mr. President. The bill that I introduced would prevent these types of unethical practices by people in constitutional state officers by requiring that constitutional officers follow the same competitive bidding requirements that state agencies already have to follow. So existing statute requires agencies to go through a public competitive bidding process to contract for any state services that would total more than $50,000. These ads that Treasurer Moranti was running were $600,000. So this definitely would have been encompassed under this bill. And the law as it exists now, it doesn't apply to any state constitutional officers or the executive branch agencies that they lead. And in the case of the Moranti ads, the treasurer budgeted $600,000 of state funds for an alleged
Time,
public
Senator.
service campaign. Thank you, Mr. President.
Senator Michaela Cavanaugh, you're recognized.
Thank you, Mr. President. I'm fascinated by this conversation. I'm now on the NADC website. I was genuinely trying to keep my comments germane to the bill, but based on that last vote, I don't think it matters. So I'm just going to riff about whatever it is I want to talk about. I have this mug on my desk, and it's been here for, I don't know, a couple of years. It's a white mug. It's got black font on it. It's got a lot of words on it. I don't know what the font is. If it's, I always forget serif versus sans serif, which is the one that has like a little bit of a flare on it. Serif. It is serif font. And it's big enough that I can read it from here. And it's very amusing. And it was a gift from my staff my first year. And I've never utilized this mug in floor debate. And people are probably like, why would you utilize your mug in floor debate? It's a mug with just a lot of words on it. So on one side, it starts out with, wow, all that text on a mug, and it's probably saying something important. Wait, no, it's just some meta commentary on the text itself. What a waste of time. This is a bad mug. Hold on. Got to turn it around again. On the other side. Wow, even more text. Is it anything new or the same as the other side? Nope. It's still this self-aware nonsense. So why did I get this mug? This is not a good mug. This is a bad mug. So it's this white mug with just black serif font on it. I find it amusing, so I just have it sitting on my desk. It actually is not a bad mug. It is if you are a connoisseur of mugs, I like this mug because it's not narrow, but narrow enough that it'll fit in most cup holders in a car. I mean, it doesn't have a lid, so whatever. But if you're in a pinch and you don't have like a thermos with a lid, this mug will fit in the cup holder in the car. And it's narrow enough, but it's not so narrow that it's like, why do I have this mug? Because there's nothing in it, because it's too narrow. And so it's wide enough for that. And it's tall enough that like you can have it filled pretty well, but still have a lot of space so that it's not splashing all over your car. And what I find is if you have it filled too much, your coffee mug filled too much, that it'll start to cool down faster. This is a problem I have with those coffee mugs that are like a big saucer type coffee mug, is that I feel like, first of all, it's more surface area being exposed to the air. And so as such, it cools down faster. So you got to have this like nice balance of, is your coffee going to cool down? You want it to cool down fast enough for you to drink your hot coffee, but not so fast that then you're drinking lukewarm or room temperature coffee. It's a real conundrum, the coffee mug conundrum. So whenever I find a good mug, I get real excited about it because, a good mug. I do like big mugs, however, because I like to drink an obscene amount of coffee. So again, it is the mug conundrum. What size of mug is the right size? Also shape. These are important factors that go into a mug selection. At home, I have a variety of mugs. We have the mugs that are like a set that we got when we got married. And then we have another set of mugs that maybe one of us had before we got married. I don't know. And then we have the random mugs that you get over time. And I have one really big mug, but it's also tall. That is just like my absolute favorite. And it's always
That's
in the
your time,
dishwasher.
Senator.
Thank you.
Thank you, Senator Kavanaugh. Senator Hunt, you're recognized to speak.
Thank you, Mr. President. Michaela, Senator Kavanaugh, you're out of your mind for that one. Not the mug conundrum. I'm 70% disappointed and 30% impressed. Really good. Okay. I do have a point to make about, I was really trying not to crack up. I do have a point to make about government oversight. And Senator Kavanaugh, you got to be bluffing. I can't believe that what you said earlier was serious, that you're surprised people didn't support your amendment. First of all, no one in here is supporting anything you're introducing all year, whether that's a bill to give Senator Kathleen Kauth $1 million a day or an amendment to provide government oversight. That's not happening. And so the surprise is not plausible to me. But talking about my bill, LB 485, which would improve government oversight for people in constitutional offices, it would prevent these types of unethical practices, such as what happened in the state treasurer's office in 2019, by requiring that they follow the exact same competitive bidding requirements that state agencies already have to follow. And these statutes as they exist right now, they don't apply to state constitutional officers, and they don't apply to the executive branch agencies that they lead. So in the case of the Treasurer Moranti ads, he budgeted $600,000 of taxpayer dollars for what was meant to be a public service campaign for unclaimed property awareness, but he didn't seek any bids for that contract. So then who got the contract? The company that did all his campaign ads, the company where he was listed as a director of that company, a company he had previously worked for. How is that ethical? And it's the same question I have about how he rented for a 10-year lease in this strip mall, a new office for the state treasurer, that didn't even have a sign on it. How is there any public accountability for that? When is it open? It's not listed on their website. Who's there staffing it? What services do they provide? If I, as a taxpayer, wanted to go to that office to have a question about unclaimed property or have a question about a child college savings account, would I even be able to do that? Or are we just throwing away $57,000 a year for nothing on that deal? And who's benefiting from the deal? We know that Victory Enterprises benefited from his deal with the commercials. We cannot call them public service announcements. They were commercials, campaign ads at worst, commercials at best. We know that a friend of his benefited from those and that he may have directly benefited from that as well. I'd like to know. And I have the same question about the office. Without this bill that I introduced, without LB 485, the door continues to be wide open for constitutional officers like Treasurer John Moranti to give huge taxpayer-funded handouts to their friends, to their former employers or employees, to future campaign consultants, and they can do that without any legal repercussions. I think we can all see that this is an issue of fairness. It's an issue of government transparency. And without this, we're really leaving the door open for abuse within the system. So the last time this bill was heard before this year was 2020, and there were no opponents, there was no neutral testimony. This year when I introduced it, there were no opponents and there was no neutral testimony, and it never got a priority, but it's one of those things that's just a good governance issue. I'll also note that after the last time these bills were heard, Treasurer Moranti said he would be happy to comply with whatever rules the legislature imposes on constitutional officers. So it's not my intention to put a whole bunch of criticism on him as an individual. It's just that the choices he made in his position shed light on the fact that our statutes have some glaring holes in them that allow for some unethical practices. Thank you, Mr. President.
Thank you, Senator. Senator Day, you're recognized to speak.
Thank you, Mr. President. I yield my time to Senator Kavanaugh.
Senator Michaela Kavanaugh, you have 4 minutes and 51 seconds.
Thank you, Mr. President. Senator Hunt, that was all for you. I knew you were dying to know my feelings on coffee mugs, shape, form. I haven't even gotten to color palette, whether it's serif font or sans serif font. There's a lot to unpack. I today have two different thermoses. I've got my water thermos and I've got my coffee thermos. I usually have both. I haven't, at the start of session, I wasn't great about having a water thermos. And so I was using the paper cups in back. And I like to avoid that as much as possible. Be more ecologically minded. So I appreciate Senator Hunt's comments that obviously I was naive. And I was naive. I got wrapped up in the whole interesting substantive conversation of it all. Having substantive conversation off the mic with colleagues about what was going on and what's in the bill. I got caught up in it thinking, we're doing our jobs. We're governing. This is terrific. I got caught up in that. So that is on me, colleagues. I apologize. I should not be disappointed in you continuing to act against your own political interests. I should have known that that is exactly what would have happened. So apologies for that naivete. I am looking over Nebraska accountability and disclosure filings because that's a fun thing to do. It's fun to see who gave to who, who gave what, how much did they give to this person or this entity or this political party, et cetera, et cetera. And I agree with what Senator Hunt is talking about with, we do have a lot of holes. And for days, I've been reading from a transcript from a deposition in regards to the lawsuit that was when St. Francis Ministries, the child welfare contract that was transferred from Promise Ship in 2019 to St. Francis Ministries for the Eastern Service Area. There was a lawsuit trying to seek an injunction to make that not happen. So I've been reading from the transcript of the deposition of one of the people that worked for the state agency at that time. And it really, the reason behind all of that is because I want to continue to shine a light on, and I've introduced legislation around this, but I want to continue to shine a light on the complete lack of process, integrity, and transparency in our procurement in the state of Nebraska, which goes to exactly what Senator Hunt is talking about when it comes to just leasing a 10-year lease on a building when you're in an elected position. I mean, it must be nice to know that you don't have to worry about getting reelected.
1 minute.
Yes. Don't have to worry about it. Of course you'll be there 10 years. Why wouldn't you? You run unopposed anyways. So yeah, there's a lot of money flowing. There's a lot of money flowing, like tax dollars flowing, and then there's a lot of money flowing. There's a lot of contracts being awarded. There's a lot of campaign donations coming in. There's a lot of money flowing in and out. And we haven't really made an effort as a governing body to have as much oversight on that, or even just transparency on that, as we could. We could be doing a lot more as a governing body. And, you know, we've got campaign finance.
That's your time, Senator. You're next in the queue, and that's your final time before your close.
Thank you, Mr. President. We've got campaign finance law bills introduced that probably won't see the light of day. We've got procurement bills introduced that probably won't see the light of day. We've got lots of government integrity things that keep being introduced but won't see the light of day. We vote to take away our own authority and give it to the governor, to the executive branch. I mean, I don't even think we should bother with the budget debate. The Appropriations Committee just spoke, unified, that they were fine with giving the governor authority over $240 million. So why even go through the budget debate? We can just go to the governor's budget. We don't have to debate it. If we do nothing, it's automatic. I don't know why you all are spinning your wheels doing so much work. You don't seem interested in having your own power and authority. You do seem interested in giving it away to a person down the hall in a different branch of government. It's not their job. Without a hearing, mind you, without a hearing. Y'all voted to give the governor $240 million with no legislative oversight, without a hearing. Okay. So yeah, I'm going to talk about coffee mugs because coffee brings me joy. So why not talk about coffee mugs? Government oversight also, you know, is something I'm interested in, brings me joy, but I spent an hour talking about that and didn't really mean anything. So my coffee mugs. I like to have two, one for water, one for coffee. And I oftentimes, people keep giving me stickers, and they're, you know, fun stickers that you can like put on a coffee thermos and doesn't get ruined in the dishwasher. So I've been adding some of my coffee thermoses have like so many stickers on them, and the one I have today doesn't have any, which I'm kind of surprised that it doesn't have any. This is not a call for people to give me stickers. I have more stickers than I know what to do with. You do not need to give me more stickers. Just want that said for the record. I got a lot of stickers. I just haven't had a chance to apparently put them on my coffee mug today. I do have one that is one of my personal favorites, and it is a bee with its wings expanded, and it says, "Mind your own beeswax." I think that one's pretty funny. And I think that one's pretty apropos when it comes to like government overreach, like mind your own beeswax, get out of my house, get out of my kitchen. So what I was talking about was my favorite coffee mug. It's this really big one. And it says, I'm not going to get exactly right, something like, a friend gave it to me, like the best man for a job is a woman. And my husband keeps using it. And I'm like, this is, first of all, stylistically, my favorite coffee mug. It's big, but it's also tall. You cannot take this one in the car. It will not fit in the car cup holder. It won't. I'm talking to the pages now. Just this is a pro tip. This particular mug is really big. I've actually taken it in the car because I drive a minivan, and there's a console in the middle with 2 coffee cup holders, but then like a flat spot. And sometimes I'll take it and I'll set it on the flat spot. Not a good idea. It splashes everywhere. So this is not a car coffee mug, but it is my favorite. And it's always in the dishwasher, not because my husband's always using it, but it is a favorite, I think, of him as well. And so then there's the next tier down coffee mug, which is one that has this like extra like lip flat bottom. And I like that one because then like on the weekends, if I'm sitting in the living room, we have a sliding door, like watch the squirrels outside. If I'm sitting in the living room with the kids drinking my coffee, I can actually set it next to me on the couch. And it's like it's got its own little table because it's so flat. So that's another one that I really enjoy and appreciate. But not stylistically, like as far as the shape goes, but my favorite is this one that I had made for my husband.
That's your time, Senator.
All right, I'll come.
Senator John Kavanaugh, you're recognized to speak.
Thank you, Mr. President. Well, I just want to get part of the conversation. I haven't talked today. So we're on AM 1094. I always look at that one, even though this one's probably easier for me to see. AM 1094 to AM 870 to LB 683. And this says strike and serve at the pleasure of. So I'm going to go out on a limb and assume that this is striking that the individual appointed is serving at the pleasure of the governor. I guess I don't know how I feel about that. I've been listening to this debate. This is an interesting one for me. I don't usually have my opinion, about where I'm at, but I'm still listening, trying to decide how I'm going to vote on the underlying bill. And I'd continue listening to the conversation about this amendment, and I would yield my time to Senator Hunt if she would like it.
Senator Hunt, that's 4 minutes.
Thank you, Mr. President. Thank you, Senator John Kavanaugh. I have some more things to say on this track that I was on, and I thought I could probably get this done in about 10 minutes, and it took me longer to read it. And I do this thing where I read, and then I go off, and then I look back, and I've only read like one line, so I've got to get back to this. But Senator Michaela Kavanaugh had me thinking about my favorite mug, and I don't like mugs. I don't like the word mug. I think it's ugly. I think the cups themselves are very ugly aesthetically. I don't like having that around me. But I have one that I like, and it's by this artist, David Shrigley. And if you've ever seen online, there's this really famous tea house in London called Sketch, and they have this room inside of it that's all pink velvet. So if you're ever looking at like Instagram or aesthetic things, maybe you've seen this room because it's kind of famous. And he's done all the art inside that restaurant, David Shrigley. But he designed a mug that says opening hours, Sunday closed, Monday closed, Tuesday closed, Wednesday, Thursday, Friday, Saturday closed. And that's my favorite mug as a retail girl who's been a shop girl for about 20 years. So with the report about the Treasurer's Office's decisions that raised red flags in 2019, two separate statutory oversight issues emerged. One, which I addressed in my bill LB 485 this year, and I've also introduced in previous years. One had to do with requiring constitutional offices to follow a competitive bidding process for state services that would exceed $50,000. So if the service is going to be more than 50K, you got to get bids. That's how we know we're being judicious with taxpayer money. And it would make it so that state constitutional offices had to do that too, just like other agencies. It's literally such a good idea. Why is it that just because something is under the executive branch, they can give out these contracts without getting any bids? Don't you see that that's almost tailor-made for corruption, for people to give out favors to their friends? I have to think at this point, after all these years of trying to change that, the reason we don't have the law is because that's what they want to do on purpose. They want to give these contracts to their friends. They don't want to have to stop doing it. Of course, if we pass this law, they could still get bids and then give the contract to their friend anyway. I mean, it's like, Swiss cheese. There's always another way to.
1 minute.
Thank you, Mr. President. There's always another way to get around the law. In that case, Treasurer Moranti's office paid all of the state money to Victory Enterprises, a company that Moranti had previously been employed by in a leadership role, which was already also responsible for his own personal campaign ads. So the other part of this that I think that we need to address is something to say that no state constitutional officer should be allowed to use state funds for campaigning or self-promotion at any time. Right now, as the law exists, you can't use state funds for campaigning or self-promotion during election years. I think we should change that to be all the time, not just election years. And I'm getting notifications on my screen here from people who heard me mention Sketch in London. Yes, it's gorgeous, and you should look up the work of artist David Strigley. Thank you, Mr. President.
Thank you, Senator Hunt. Senator Conrad, you're recognized to speak. Senator Hunt, you're recognized to speak, and this is your last time.
Thank you, Mr. President. The other part of this issue that I addressed in another bill this year, LB 486, is to say that no state constitutional officer should be allowed to use state funds for campaigning or self-promotion at any time. And this would have solved the problem with the ads that were running on television that were produced by Victory Enterprises. I remember hearing from a lot of people when those ads that were ostensibly for the state treasurer's office, but seemed more like campaign ads for Treasurer Moranti. I heard from a lot of people when those aired, and it very much had the feeling of a campaign ad. It featured Treasurer Moranti smiling and waving, his family members, his name really bold. It might have been his campaign logo. I don't really know. So it's all kind of fishy. And while it's definitely reasonable that the treasurer would need to spread public awareness about the services they offer, there's a difference between a public service announcement that's just talking about the services of an agency, the services of an institution, what the treasurer literally does, spending some money to make sure that the public knows about that, what kind of, help they can get from this person who they elected and who is accountable to them. So it's reasonable that they would want to spread awareness about something like that, but there's a difference between a public service announcement and a blatant campaign ad. So with this bill that I introduced, we make a change to the existing statute that prohibits those types of ads for constitutional officers during election years, and we change it to prohibit those kinds of ads at any time. So not just election years, but all of the time, they would not be able to use those funds for that kind of thing. The legislature passed the original ban that said you can't use it during election years in 2002 because of what they perceived as an increase in incumbents spending money on ads about their offices, particularly during campaign years. And these ads would typically include the name of the incumbent, pictures of their family, things that basically made them indistinguishable from campaign ads. So in 2002, the legislature passed this original ban because they could see that incumbents were spending more and more money on these types of campaign ads during election years. And honestly, it's kind of smart. I mean, if it's legal for you to use taxpayer money to run an ad that will help you get reelected, I can see why a conservative Republican would do that. So when these ads feature the name of the office holder in a way that makes them indistinguishable from campaign ads, though, that's a problem. And in 2002, senators thought that the increase in these types of ads warranted a ban on them during election years, but only if the ad referred to the office holder by name, since the self-promotional aspect is what gave incumbents an unfair advantage. So one of the bills I introduced this year, LB 486, which had no opponents, no neutral testimony, everyone thought it was their favorite bill ever to hear them tell it. This bill, LB 486, would simply extend that ban to every year, which would effectively make office holders unable to use state funds for this purpose ever. I think it would be great to turn on the TV and see an ad for the state treasurer's office.
1 minute.
Thank you, Mr. President. That doesn't even mention who the state treasurer is. Given that it's an elected position, that year to year it can change who that person is, we're really not advertising that person. We're advertising and promoting and spreading awareness and education about the function of that office as a constitutional office in Nebraska, the role that that office plays in oversight, but also services for taxpayers that fund that office, and just giving them information about what kinds of things are available to them if they were to access that office. It doesn't have to be about the treasurer's name or what his family looks like, or even like the different things that he's accomplished since he was elected. It could be strictly informational. And I think that would be better for us politically. Anytime, since I was...
That's your time, Senator.
Thank you, Mr. President.
Thank you, Senator Hunt. Senator Day, you're recognized to speak.
Thank you, Mr. President. I yield my time to Senator Hunt.
Senator Hunt, that's 4 minutes, 58 seconds.
Thank you, Mr. President, and thank you, Senator Day. Since I was young, and I bet a lot of you agree, it seems like every election is the most important election of our life. And the people have never been more divided than they are today. And I tell you, as a liberal Democrat, as a leftist, I wish Mitt Romney was president over Donald Trump. I remember thinking Mitt Romney could be the worst thing that ever happened to this country, and really believing that. And I look back now and I think how crazy that sounds, and that's not true at all. And I don't think that today. It just shows what a backslide we've really had in terms of division in this country. And as political campaigns get hotter and hotter and hotter, there's someone in this body who accused their opponent of being a groomer. Since when have we seen that kind of language in politics, basically accusing your opponent of pedophilia? That's insane. There's no place for that in a campaign, but now it's common practice. You hear the way stuff goes in here. I mean, I wish we were doing nothing but talking about property tax relief. We'll do that tomorrow. I wish we could get through more than 21 bills this session, but we can't. Why not? Is it because Megan and Michaela are doing something? No, it's because all of you want to take away the right to health care for trans and LGBTQ youth, which, is that a hot button issue in this country right now? Yes. Is Tucker Carlson talking about it every day? Yes. Is that how we run things in Nebraska? No. No, and we never have. So when people from national media outlets contact us and they go, they think that this filibuster is extreme or an overreaction or something radical. Because, I mean, maybe it's because they're used to people rolling over and taking it. Maybe it's because state to state, what we typically see is a lot of lip service, a lot of words, a lot of threats, a lot of verbal fight for the rights of the people of that state, but they don't see it backed up with action. And we're backing it up with action because enough is enough. We're on the hierarchy of needs here. We're on the pyramid. The baseline of the hierarchy of needs, food, shelter, safety. When you take the safety away from people in this state who are so vulnerable, we're not going to be able to move on to the other stuff. This is such a divisive and toxic topic that in previous years, it would have been gate kept in committee, wouldn't have let it out of committee to come out here, because this isn't what we stand for. This isn't what we actually do. All of you who say that, you know, trans parents are grooming and that you don't understand why a child would be trans and you don't support it, I gotta tell you, I might be wrong, but you might feel different if this was someone you loved and knew. Just like how a lot of you changed your minds about same-sex relationships and civil unions in the 90s and gay marriage because it became more and more prevalent. And it's not because more people were gay, it's because culture and society was finally more affirming and accepting of people with those identities. So they actually felt safe coming out and saying what they really are.
1 minute.
So I would submit to all of you that if you don't know any gay people, or if you don't know any trans people, you probably do. They just don't feel safe telling you that. And I think we can measure the success of our society by how safe we make people feel. We can measure the success of Nebraska by how safe people feel in our presence. Do you think that people felt safe when they waited 7+ hours, Senator Ben Hansen, to come testify in your committee, to find out they had to leave and they weren't going to get an opportunity to speak, and it was only 8 p.m.? 4 hours left in the day, man. Do you think that made people feel safe? Do you think it makes people feel safe to hear the kinds of things that you folks say on the microphone about these kids who have nothing wrong with them? As my child said, no one bullies him except my coworkers.
That's your time, Senator.
Thank you, Mr. President.
Thank you, Senator Hunt. Senator Dungan, you're recognized to speak.
Thank you, Mr. President. Colleagues, we're debating this amendment here, 1094, which my reading of it when I was listening strikes the language "at the pleasure of," and I think it's interesting. I did just a quick little bit of research here while we've been listening, and there's just kind of an aside and a brief history lesson. Even though the amendment sounds kind of goofy on the face of it to take out the language "at the pleasure of," it's really interesting how there's actually a long and storied history that I won't bore you with of what the words "at the pleasure of" mean with regard to the law. For example, the first time it appeared in English law was back in about the 12th or 13th century. And what it essentially meant in their law at that point in time was that you couldn't do anything without the king's permission. The first time we started to see it in a more modern era was, or the time we saw it change, was in the early 1700s. They actually modified it from the pleasure of the king to during good behavior with regard to judges and whether they would serve indefinitely or if they were serving at the pleasure of the king. Then there was a big debate about whether or not it should be at the pleasure of the president in the Constitution or for good behavior with regard to judges on the Supreme Court. Ultimately, during good behavior won out. And then there's been a longer conversation into a much more modern era about cabinet members and whether they serve at the pleasure of the president and what counts as serving at the pleasure of the president. And I think that is part of the thing that led to Andrew Jackson's impeachment. So the reason I point that out is when we look at this amendment and talk about the language "at the pleasure of," it really does substantively change the legislation. And so I think Senator Michaela Cavanaugh's point of removing that does really, I think, have bearing on a discussion of the amount of authority given to the governor. So I just wanted to point out that this language does have significant historical precedence and it does carry with it significant weight. And with that, I'd yield the rest of my time to Senator Hunt.
Senator Hunt, that's 3 minutes, 10 seconds.
Thank you, Mr. President. Any senators who are at home watching right now, who've left early and decide to take off early today, you're doing the right thing. Nothing is going to happen here today, and none of you really need to be here for the rest of the day either. I own a stationery store in my district, and I do a lot of importing of stationery and product, mostly from Japan and also from Korea, because those are countries that have really, really interesting stationery. And there's shops like Crane or like Paper Source that are chains that have a lot of really well-known stationery brands and stuff like that. If you're trying to get wedding invitations or something, you're probably going to go to Crane. If you're trying to get birthday invitations, you're probably going to go to Paper Source. And if you come to me, you're going to get interesting papers from other countries and things maybe you haven't seen before. And so that's kind of my niche. But I think if I was a conservative Republican, Treasurer John Moranti might give me $57,000 to get some envelopes for his office. So I wish sometimes that I had made different choices and I could be reaping these benefits that other conservative Republicans are getting who are local business owners. You know, whether it's in the form of a tax break or a tax incentive or a tax credit or what have you, you know, those aren't really things that I'm benefiting from. But in 2002, the Nebraska Legislature passed a law saying that constitutional officers, so that's the governor, lieutenant governor, auditor, secretary of state, state treasurer. I think that's it. I'm probably forgetting something. If I'm forgetting something, it's probably really obvious. And it's like me calculating something times 10 on my calculator. But in 2002, the legislature made it illegal for state officers to use public funds to run ads during election years because they were running ads that felt too much like campaign ads.
1 minute.
Thank you, Mr. President. And senators thought that a ban on these ads was warranted because there was such a huge increase in the number of them during campaign years. And a bill I introduced this year in Government Committee, LB 486, it extends this existing ban to every year, which would effectively make state constitutional office holders totally unable to use state funds to promote themselves. I'll point out one reason I think this is a good policy change is because this wouldn't prevent office holders from running ads or distributing promotional materials completely. Instead, it would limit the medium and the source of funding for this purpose only if the material had the office holder's name on it. So it would really encourage offices like the Treasurer's Office to promote the work they do without promoting who necessarily won the last election to be state treasurer, because that's not the point of the office. That's not the purpose of the job.
That's your time, Senator.
Thank you, Mr. President.
Thank you, Senator Hunt. Mr. Clerk, for items.
Mr. President, some items, motions to be printed, motion to be printed from Senator Hunt, legislative bill 327, 335, Senator Michaela Cavanaugh to LB 341, Senator Hunt to LB 343, Senator Michaela Cavanaugh to LB 348, and 385, 387. Additionally, amendments to be printed, Senator Erdman to LB 243 and Senator Hunt to LB 243. That's all I have this time, Mr. President.
Thank you, Mr. Clerk. Senator John Kavanaugh, you're recognized to speak.
Thank you, Mr. President. I appreciated Senator Dungan's history lesson on the last round speaking. I always enjoy fun facts. And I just appreciated Senator Hunt talking about her shop. I've been there. I enjoyed it. And I did a lot of my Christmas shopping there. And one particular item that was a big hit was these very small colored pencils that come in like a pack of little colored pencils. And it was so popular with kids. It was so popular with the kids that it became a subject of fighting. I was glad I bought 2 of them. But my kids and their cousins fought over the miniature colored pencils. But I got a number of items there for many members of my family. You also have jewelry there, which I got some jewelry for my wife that she enjoyed and wears all the time, set of earrings. So I again, still trying to decide where I'm at on this bill. I was reading the committee statement, and I just thought I'd focus some of the conversation on that. So this is a summary of the proposed changes. The legislature's intent is that the state broadband coordinator duties, the section is amended by striking the current intent in the language creating this position of state broadband coordinator, which was to be located in the Office of Chief Information Officer. Section is revised to establish the Nebraska Broadband Office headed by the Director of Broadband. The Director of Broadband is to be appointed by the governor and is subject to legislative confirmation. The office is to be located with the Nebraska Department of Transportation for administrative and budget purposes. All administrative and budget decisions for the office shall be made by the Director of Broadband. So I think the conversation we're having here is about that appointment and retention of that Director of Broadband. And so I think Senator Dungan's conversation about that was very apt about what it means to serve at the pleasure. So the duties of the broadband office are to engage in outreach and collaboration with all interested parties, develop a broadband strategic plan for the state, which I think is, so I've heard people talking about, is one of the important issues we have going here. And I generally don't engage on broadband issues. I'm not on the transportation committee, and there are a lot of technical aspects to these bills, and there's a lot of, interests being the telecom industries and regulated businesses all over the state of Nebraska who are interested in this. And then, of course, I always like to hear from Senator Bosselman about the specific concerns of Nebraskans in their ability to watch television, which I is a genuine seriousness. I just like to give Senator Bosselman a hard time about it. But we've discovered specifically in the pandemic how important access to internet is for everybody. Broadband, my interpretation of broadband, I guess, is internet. It's a type of internet. And, when everybody went to remote work and remote school, it became an equity issue and clear that if people don't have access to reliable broadband internet services, they wouldn't be able to participate in school. They wouldn't be able to work remotely. And then it would have to be, their employer or their school would have to find some workaround, or people would have to put themselves in jeopardy or miss work because of that. So that put a fine point on the fact that we are not up to date and meeting our obligation to serve everyone in the state of Nebraska.
One minute.
Thank you, Mr. President. And so I think it is really important that this conversation comes from, I think, a desire to more quickly build out our broadband system in the state. And that's why people are really interested in, that's why the governor, I think, has proposed this change. That's why people have kind of rallied around this change and are just desperate for a faster implementation of this broadband service to everybody, particularly around the strategic plan. And I guess the one reason I agree with that concern, but the one reason I have hesitation about this bill is ultimately the taking away of power from an elected board and putting it into an appointee under the governor's office. I just have real concerns about that as a matter of policy. I understand the reason people want to find a more efficient way to do this, but sometimes efficiency is not going to be the best policy. So thank you, Mr. President.
That's your time, Senator. Senator Day, you're recognized to speak, and this is your last opportunity on this amendment.
Thank you, Mr. President. I yield my time to Senator Michaela Cavanaugh.
Senator Michaela Cavanaugh, you have 4 minutes, 55 seconds.
Thank you, Mr. President. Thank you, Senator Day. So I just took a mental break from talking about the bill for a little bit to talk about coffee mugs. I needed to shake off that vote. But this is a really important bill. It does something really big, really drastic. Not drastic in a bad way necessarily, but it is drastic. It is a drastic change, a drastic shift. We are creating a new office, and we should not enter into that lightly. We don't have a sunset on this for some very valid reasons. One being, we need to hire a high-level professional to execute the BEAD program the broadband program. It is very difficult to hire somebody of that caliber when there is an end date to their job. And so having the sunset doesn't really make sense. I get that. But we also aren't establishing a long-term plan for the office. So this office is being established to take an existing program from an existing elected body and move it from that existing elected body to a new entity, newly created, newly forged, with not really a long-term plan or even an understanding of, if we are doing this, are we creating a new department, a new agency, a permanent office, a temporary office? So it's a big deal. And it is not something that we should do without conversation. Unfortunately, people have disengaged from the conversation and have stopped listening. And I fear we'll vote for something without understanding what it is or what it does. I hope that's not the case. Maybe you all are studying up, learning what this is, learning what LB 683 is and does. But I am concerned. So, just going to outline some of the concerns that have been expressed to me by people outside of this chamber. The Department of Corrections, well, certainly not the Department of Corrections. The Department of Transportation is not the correct place for this. There's a constitutional mandate that gives the PSC jurisdiction of common carriers, which includes telephone carrier companies providing voice and broadband services. This is a big question, a big, big question. Is this constitutional? We have not defined in Nebraska or federally broadband as a common carrier or not a common carrier. It is not defined. The Public Service Commission has been given authority over common carriers, but we have also given them authority over broadband. We are taking part of that broadband authority away from them and putting it into a new office.
1 minute.
In the governor's administration, which I'm still very unclear into how that works. If it's not a new agency, but it's in an agency, but it's not in the agency. I'm very unclear on that. I think this is uncharted waters. So we have that piece of it. But we're doing this, and we don't know yet if what we're doing is clearly constitutional or not, because we cannot give common carrier duties, take them away from the PSC and give them to the governor. We clearly cannot do that. And it seems like we are getting adjacent to those waters if we are not fully in them. That is concerning.
That's your time, Senator. Senator Breezy has some guests in the north balconies. High school students from a boarding school in Solingen, Germany. Please stand and be recognized by the Nebraska Legislature. Senator Eibach has guests in the north balcony. High school students from Juanita Palisade High School. Please stand and be recognized. Senator Dungan, you're recognized to speak.
Thank you, Mr. President. We recognize people in the balcony on a pretty regular basis, but when they said you were from Germany, there was an audible gasp down here. Everyone was like, ooh, so thank you for that. I appreciate having you here. It's really, really cool. I would yield the remainder of my time to Senator Hunt.
Senator Hunt, 4 minutes, 45 seconds.
Thank you so much. Y'all are from Germany? Willkommen. Es freut mich. Okay. We got a phone call from the state penitentiary from somebody who was very encouraging and telling us to keep it up with the filibuster. So that meant a lot to me. Let me see here. I was wondering if Senator Kavanaugh would yield to a question. Michaela Kavanaugh.
Senator Michaela Cavanaugh, will you yield to a question?
Yes.
You're on transportation.
Yes.
In this hearing for LB 683, was there any opposition testimony?
There was not.
Was there neutral?
There was.
How did that neutral testimony feel?
Well, it felt like it was negative, but also I discussed that with one of the members of the PSC that came and testified in neutral. And I said, your neutral testimony feels like you're actually in opposition. And they said they weren't in support.
Okay. Do you think that, so I agree with Senator McKinney and Senator Wayne, who have kind of a, crusade is too strong of a word, but who have a mission to make it so that state agencies come in neutral on bills instead of as proponents or opponents. What are your thoughts on that type of
I think that is
policy?
absolutely what state agencies should be. The PSC is not a state agency, but yes.
Right, right.
Yeah, I agree. I agree with that wholeheartedly.
Why do you think the PSC came in neutral?
I think that this is something that was done at the behest of the governor, and it is difficult for anyone to come in opposition to anything that is done at the behest of the governor.
Thank you, Senator Kavanaugh.
Yes.
I think that when we talk about the tribalism and the division that we have in our country, this is part and parcel of that entire problem, that we have elected offices that only wealthy people can afford to hold. And this legislature is not real different. I mean, making $12,000 a year, you can really only afford to have this job unless if you have a wealthy spouse or partner that can support you, or if you're retired and you don't need the income, or if you're young and you're used to being broke, or if you hold down another job. And this cuts out a lot of people from the opportunity to serve. I drive back and forth every day. My son is at track practice right now, and then he has band practice, and then he'll be home, and I think I'm likely to see him for dinner today, but a lot of days I don't. And if I was living in Kearney or honestly anything more than an hour's drive away, there's no way I would be able to have this kind of position. And it has nothing to do with, to say nothing about the money, to say nothing about the pay, just the demands that this has, and then the way you're compensated so little for it. If somebody needed to pay for childcare or pay for an apartment here in order to
1 minute.
be able to live here while we're in session, that really cuts out a huge portion of Nebraskans from the opportunity to serve. And that's a big problem. So what that does is it concentrates wealth into the elected class. The class of people in Nebraska who are able to be elected and able to serve are more likely to be wealthy than the rest of the state. But at the same time, they don't express power. They don't express independent judgment or purpose with the work that they do. They reflect the power that they see as above them, whether that's a governor or whether that's a U.S. senator, as in Pete Ricketts, who funded a lot of your campaigns to a degree that you may not be here without him. And we know that he doesn't let you forget that. So what good is having the power when...
That's your time, Senator.
Thank you, Mr. President.
Senator Michaela Cavanaugh, you're recognized to close on the amendment.
Thank you, Mr. President. Colleagues, this amendment just strikes the language that the director of the office serves at the pleasure of the governor. So again, LB 683 is creating a new office of broadband, the BEAD program, taking it away from the PSC. So I was talking about constitutional question around it. It also would question the appropriate level of technical expertise that the Department of Transportation would have in overseeing this. They have no experience with deploying broadband, and part of the conversation around this bill was that they were the right place because of efficiencies, alternative project delivery, that not entirely clear what that's going to mean. There's a strategic plan that was already developed by the previous administration. Conducting advocacy on a federal level for broadband deployment. PSC already is doing that and has been for decades through the National Association of Regulatory Utility Commissioners. I understand aggravation with things moving slowly. I feel like a lot of the hearings that I have had this year, particularly the 5th year I've been on transportation, the hearings around broadband felt like, whew, how many times have I heard this? I know what the arguments are. I know what the conversation is. Nothing changes. Nothing changes. I get the frustration around it. I'm not sure how creating a new office and taking away authority from an elected body is going to fix that. It feels like it's creating additional government. And I don't know that that's what we want to do, intend to do. But that's what we will do with LB 683. We will create more government. And we will create a new office. That office will come with expenses. That office will come with additional needs and infrastructure. It currently is a program within the purview of the Public Service Commission. Being a program within the purview of the PSC means it does not need to have a new office set up. It does not need to have a sunset date. Just like any other program that the PSC runs, and they do run other programs.
1 minute.
When there's no more funding, there's no more program. I don't know that that's the right answer, but I don't think that bloating our state government further is necessarily the right answer either. And I'd like us to find the right answer before we make this drastic step. I'd like to see us look into this further and have a strategic plan and vision for the Office of Broadband. Not just quickly moving a program from one jurisdiction to another. And that's really what we're doing. We're just moving this from one jurisdiction to another, which is ultimately going to result in bigger government. So there we have it. I'd like a call of the House and a roll call vote. Thank you, Mr. President.
Thank you, Senator. That's your time. There's been a request to place the House under call. The question is, shall the House go under call? All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
11 ayes, 5 nays, place House under call.
The House is under call. Senators, please record your presence. Those unexcused senators outside the chamber, please return to the chamber and record your presence. All unauthorized personnel, please leave the floor. The House is under call. Senators Wishart, Kauth, Frederickson, Clemens, McDonald, and John Kavanaugh, please return to the chamber. The House is under call. All unexcused members are now present. The question is the adoption of AM 1094. There's been a request for a roll call vote. Mr. Clerk.
Senator Aguilar, Senator Albright. Voting no. Senator Arch. Voting no. Senator Armendariz. Voting no. Senator Ballard. Voting no. Senator Blood. Senator Bostar. Not voting. Senator Bostelman. Voting no. Senator Brandt. Voting no. Senator Brewer. Voting no. Senator Breezy. Voting no. Senator John Kavanaugh. Voting yes. Senator Michaela Kavanaugh. Voting yes. Senator Clements. Voting no. Senator Conrad. Voting yes. Senator Day. Voting yes. Senator DeBoer. Voting no. Senator DeKay. Voting no. Senator Dorn. Voting no. Senator Dover. Voting no. Senator Dungan. Voting yes. Senator Erdman. Voting no. Senator Frederickson. Voting yes. Senator Geist. Voting no. Senator Holleran. Voting no. Senator Hansen. Voting no. Senator Hardin. Voting no. Senator Holdcroft. Voting no. Senator Hughes. Voting no. Senator Hunt. Voting yes. Senator Ibach. Voting no. Senator Jacobson. Voting no. Senator Kauth. Voting no. Senator Linehan. Voting no. Senator Lippincott. Voting no. Senator Lowe. Voting no. Senator McDonald. Voting no. Senator McKinney. Senator Mosier. Voting no. Senator Merman. Voting no. Senator Raybold. Senator Reapy. Voting no. Senator Sanders. Voting no. Senator Slama. Senator Vargas. Voting no. Senator Von Gillern. Voting no. Senator Walls. Not voting. Senator Wayne. Voting yes. Senator Wishart. Voting no. Vote is 8 ayes, 34 nays, Mr. President, on adoption of the amendment.
AM 1094 is not adopted. I raise the call. Mr. Clerk for items.
Mr. President, some items quickly. New motions. Motion be printed. Senator Michaela Kavanaugh to LB 388. Senator Hunt to LB 412. Senator Michaela Kavanaugh to LB 425. Senator and 426, 447, 461, 462, 465. Senator Hunt to LB 474. Senator Kavanaugh to LB 514. Senator Hunt to LB 516. 535, 552. Next amendment, Mr. President, to LB 680 and the committee amendments. Senator Michaela Kavanaugh would offer AM 1095.
Senator Michaela Kavanaugh, you're recognized to open on AM 1095.
Thank you, Mr. President. Colleagues, AM 1095. Let me just pull that up. The Nebraska Broadband Office shall be subject to Open Meetings Act. Pretty self-explanatory. The Public Service Commission is subject to Open Meetings Act. We are taking this away from the Public Service Commission. I would like that stipulation of government transparency and oversight to follow the program to the broadband office. Again, this is a very large federal program that's hundreds of millions of dollars that we are taking away from an elected body that is required to have many layers of government transparency, oversight, including being subject to the Open Meetings Act. So I think it would be prudent if in creating this new, possibly temporary office within the governor's administration, that it too be subject to the Open Meetings Act. Currently, there is a stipulation in the committee amendment that there should be an annual report briefing, I'm not sure what the exact terminology is, to the Committee on Transportation and Telecommunications. That's great. I appreciate that. However, that does circumvent a lot of the public's engagement in the process, because they'll already have done things. They'll come and tell us things that they've done. That's great. But they'll have done them without the transparency that currently has to happen, which is open meetings. I think a great example of a lack of transparency when we don't have open meetings is the Omaha Library Board. The Omaha Library Board did a lot of things that the public did not get to have input in, did a lot of work that the public was not a part of, that resulted in some pretty substantive changes. So, colleagues, as this broadband deployment is happening in communities across our state, in your communities, primarily rural and western Nebraska communities, not my community, this gives your constituents and the communities impacted the opportunity to participate in the process, to have their voices be heard. So this would go to page 6, line 9, and on page 6, after line 9, insert the following. The following new subsection. Okay, after, well, it doesn't quite line up. I think, oh, subsection AM 1095. Ugh. This might, no, that's, well, I'm sure this can be fixed on ENR. I think that it might be line 10 and not line 9. No, page 6. Oh, geez. I'm looking at the wrong page. Sorry. It's a long day. My eyes are tired. I apologize. Page 6, not page, I was looking at page 9. Page 6, line 9, insert after that. Okay. So it starts on line 7. Upon receipt of such report, the Transportation and Telecommunications Committee of the Legislature shall hold a public hearing to allow an opportunity for public comment on the report. Then we would be inserting the Nebraska Broadband Office shall be subject to the Open Meetings Act. So see, there is language in here that they shall hold a public hearing, to allow an opportunity for public comment on the report. So we're already put in here that they have to have a public hearing, but this would just add that extra layer. Not only that extra layer, but it also would clarify for everyone involved. It would clarify for the new office. It would clarify for the public. It would clarify for us. It would clarify for the Public Service Commission, for everyone, that what we mean by a public hearing is that they must abide by the Open Meetings Act. Not just a public hearing, but it must be posted. It must have advance notice. There's other stipulations, quorum, etc. That is important clarification. So we already are requiring the public hearing. When they have this public hearing, they must abide by Open Meetings Act. And any other meetings that they have, they must abide by the Open Meetings Act. This is important clarification. So, how much time do I have left?
2 minutes, 40 seconds.
Thank you. Sorry. Oh, apologies. Okay, so we've got an issue of the timeline, short timeline, disruptive to the timeline. We're creating a new office. We don't know what the long-term implications are of that. Nobody's really discussed what the long-term implications are of that. We don't have a great deal of transparency. We're shifting from transparency to a lack of transparency. We are also potentially bloating government and the administration. So, a few things that maybe we should be talking about as a collective body. I really think for those smaller communities, it's going to be important to have that transparency, to know what the plans are when they're coming into your community to do this deployment, how the funds are being spent, how they're being awarded, all those fun, sexy government oversight things.
1 minute.
Thank you, Mr. President. There was some conversation earlier around the courts issue. I'm not sure that we've thought those through in a appropriate way, but I believe that Senator Dungan is working on some fixes for that. I think, I could be wrong, I could have misheard, but I think he's working on some fixes for that, the court piece of it. So we have the funds need to be used in a cost-effective and accountable manner. So I'm not sure how it's effective and accountable if we are diminishing the accountability by removing the authority from.
That's your time,
Thank
Senator.
you.
Senator Conrad, you're recognized to speak.
Thank you, Mr. President, and good afternoon, colleagues. I did want to just continue to weigh in terms of the conversation. I think it has been substantive and important to tease out kind of how we not only establish a regulatory framework to ensure that we have a comprehensive policy when it comes to ensuring a good plan and facilitation of that plan to address the digital divide and broadband access for all of our citizens. I do have reservations about diluting the power of the purse in terms of appropriations and delegating that to an executive branch office or agency. I think that is potentially problematic and something that we need to have additional discussion on in between general and select file. And I'd be happy to be helpful from a legal technical perspective if I can be in that regard, because it does implicate constitutional provisions around appropriations, of course. The other thing that I do want to note is that in relation to the present amendment that's pending on the board, it will be no surprise to anyone to hear me take a moment to reflect upon Nebraska's proud and strong tradition of open government, whether that's through our public meetings laws, our open meetings laws, or our open records laws, our public records laws. The terminology for those, of course, is used interchangeably in many instances. I did want to highlight and note that in regards to open government, Senator Albright has a great bill that she's introduced many years, that has been advanced with strong support from the government committee, that also strengthens our legal framework and our strong tradition for open government and open meetings. And I'm proud to be a co-sponsor of that measure, and I hope at some point we will find a vehicle to move that forward, because I think it is critical to ensuring the public's right to weigh in on the business before various levels of government and various government entities and agencies. So considering the extraordinary interest, the high public interest in the provision of broadband services, and the significant amount of appropriations that we have to manage in order to develop, carry out, and implement our plan, I do think that at the very least we should have clarity around the fact that this new office, this new agency should be subject to the strongest possible provisions in our public records laws and our open meetings laws. And I think that will help to ensure stronger community engagement, better transparency, participation by members of the media who will be reporting on these matters. And I appreciate Senator Kavanaugh bringing forward this amendment. Thank you, Mr. President.
Thank you, Senator. Thank you, Senator. Senator Erdman, you're recognized to speak.
Thank you, Mr. President. I appreciate that. We've been sitting here for a long time today on a very well debated motion or bill 683. I have come to a conclusion after having my questions answered, visited with Senator Bosselman, who's on the committee. He explained exactly what we're trying to do and why we're trying to do it. He answered the questions that I had earlier when I spoke. And I had said that I was listening to see where we would go with this bill and what it meant. I did figure that out. I have concluded that I will be in support of LB 870 and AM 870 and LB 683. And I would encourage you to do the same, and I hope we get to it very soon. Thank you.
Thank you, Senator Erdman. Senator Hunt, you're recognized to speak.
Thank you, Mr. President. Thank you, Senator Erdman, for the update that he's gotten enough information to move on from this matter. This amendment actually hasn't been well debated because it was just introduced by Senator Kavanaugh. I understand the fatigue of maybe, Senator Erdman's back in the queue. Good. Teach me a lesson here. But, you've heard her voice a lot this session, but this is a great amendment and it's an important amendment. What it would do is it would make the Nebraska Broadband Office subject to the Open Meetings Act. And if we're going to let this office have and spend money, then we should make sure that it comes with the accountability for that and that they comply with the Open Meetings Act. If broadband is so important and worthy of state investment, which I believe it is, I think all of us believe that it is, then the public ought to know how their investment is being administered. And in the state of Nebraska, the way that we have to do that is through the Public Meetings Act, Open Meetings Act. I'm sorry. This is another example of an amendment that is a great idea. If it had been introduced by someone like Senator Brewer, we would all be voting for it and supporting it. And it's something that he actually ought to support himself as a supporter of the Open Meetings Act, as well as my colleagues on the Government, Military, and Veterans Affairs Committee. But because of the introducer, you're going to probably, predictably, not vote for this. There will probably be 6 or 7 votes for it, if that. And the rest of you will come back in when we call the House, vote against it, because you see all the other freshmen are voting against it. And so you're going to definitely do that too. And it's that every single day. It's Groundhog Day every single day, banging our heads against the wall. And why are we here? One bill. An article in the New York Times was just published, and it actually quoted our clerk, who said he has never seen a session in the legislature hang on one bill. And it sounds like this article is going to be front page New York Times tomorrow, but because of the Trump indictment, they might actually be pushing that to Saturday's paper instead. But that's exciting for our state. It's exciting that there are so many people in this country watching what our state is doing. And a big reason that they have focus on Nebraska is because of the structure of our legislature that allows us to use this time, to take this time, to make these procedural motions, to reflect the will and conversations being had by the second house, especially Senator Ben Hansen, when chairmen like you don't allow them to come in and share their views during a public hearing. It should be against the rules. I mean, I would support a rules change, Senator Erdman, if you want to draft that, to say that committee hearings have to go until midnight or until all testifiers have been heard. It doesn't mean that you all have to stay. There's nothing in the rules that say any of you have to stay in a hearing until midnight. People often leave early for different reasons. But the function of our committee hearings is to make sure that people get their voices heard. And to cut off testimony at 8 p.m., knowing how many people were snaked around the halls, lined up for 7+ hours to have their voices heard about this issue that matters to them. In this 4 minutes I've been talking, I haven't even said what bill it is. Don't have to. Haven't described it, haven't said a thing about that, don't have to. This is what this session is about now. I wish it wasn't. It's really your choice. It was your choice when you chose to pack and crack the committees so that this trash bill wasn't gate kept in where it belongs. Your cracked and packed committee voted this bill out, and now we have to take it seriously, even though most of you don't. So all you have to do is be not voting on that bill. We can get off the front page of the New York Times and get back to the work for the people of Nebraska. Thank you, Mr. President.
Thank you, Senator Hunt. Senator Erdman, you're recognized to speak. Senator Erdman waves. Senator Michaela Cavanaugh, you're recognized to speak.
Okay. I misspoke. I always say I stand for correction, and I am going to correct myself. Okay. So this does, I didn't misspeak about what this does. It does the Open Meetings Act. I misspoke about the public hearing, and thank you to Senator Walls for her questions. She's been coming to me with questions throughout the day, and I appreciate her interest and curiosity around this important issue. So I misspoke because I'm tired. I'm sorry. It's been a long week already, and I don't know what day it is. I was going to say it's Wednesday, but then I realized I think it's not Wednesday. It's Thursday, maybe. So I misspoke because I was thinking that the office was going to have a public hearing. That was incorrect. Upon receipt of the report by the legislature, the Transportation Telecommunications Committee shall hold a public hearing to allow for opportunity for public comment on the report. So that's great. We've done that with a lot of different things. And we, requiring a public hearing when a report is issued. A piece of legislation that I passed my first or my second year, kind of blurs together now, on campus sexual assault, required a public hearing. And it's all the post-secondary entities, state colleges, universities, community colleges have to submit a report. And then the education committee must have a public hearing on that report. The reason I did that, and the reason I think this is important, is that we do get a lot of reports in the legislature. They are put on the website. They are publicly available. And I think that they are underread and underappreciated. Now, first of all, if we are going to go through the process of requiring and codifying in state statute that a report must be given to us, I think the least we can do is read the report. But one way to sort of elevate the report is to require a public hearing. So I was asked once if we could get rid of the public hearing on the report that for campus sexual assault and violence. And I said, no, because then nobody will read the report. That's the whole point, is to elevate what's in the report with the public hearing. So the committee amendment requires a public hearing. I think it requires a report and a public hearing on the report. This amendment requires that the office be accountable to public hearing, the Open Meetings Act, which the Public Service Commission must do. So if we are going to move this program away from the elected body of the Public Service Commission to a newly created office where we have also given the governor carte blanche over the money, the least we can maybe do, possibly for the public, for your constituents, is to require that they be transparent in their work.
1 minute.
That is the intention of this amendment. So it does not do anything to hinder the bill. I would assume that if it did, that somebody else on the committee would stand up in opposition to it. They're not. But of course, that does not matter. Everyone will vote against it anyways, but there you go. Thank you, Mr. President.
Thank you, Senator. You're next in the queue, and that's your last opportunity before your close.
Fantastic. I didn't even realize it was in the queue. Did I put myself in the queue? Wow, I'm real tired. Okay.
This is not your close. You have this opportunity, and then you're closed.
Right. Yes, I honestly didn't realize, was I just in, I have lost track. Okay. So I think we're just about done with the day. Clearly, I am ready for a nap. And we can do this all over again tomorrow. Those that testified in the neutral capacity were Dan Wademeyer with the Public Service Commission, Andrew Vinton with Allo Communications, Chip O'Neill with the Nebraska Telecommunications Association, Brian Thompson, Consolidated Companies, Inc., and Colin Robbins, Nebraska Public Service Commission. Those that testified in support were Vicki Kramer, she's the director of the Department of Transportation, Sarah Meyer, Nebraska Rural Broadband Alliance, Julie Bushell, Ethos Connected LLC, Emily Haxby on behalf of herself, Danny DeLong for AARP, Lash Chaffin for the Nebraska League of Municipalities, and Bruce Riker for the Nebraska Farm Bureau, the Nebraska State Dairy Association, Nebraska Cattlemen, Nebraska Corn Growers Association, Nebraska Pork Producers, Nebraska Soybean Association, Nebraska Wheat Growers Association, Renewable Fuels Nebraska. I honestly do not remember what his testimony in favor was about, but I am intrigued by all of those entities. I look forward to trying to spark my memory on that one. Bruce Riker. So when people hand us their printed testimony. It is extremely helpful, especially, I mean, when we have hundreds, 800 plus bills, when we have the printed testimony, it sticks with the file of the bill. And it is very helpful to recall what was said at the committee hearing. Even more helpful when you have a bill where there are hundreds of testifiers and there's pretty much no way that I'll have total recall on all of those testimonies. Having written testimony that I can go back later and reference is a really big help. So that's just a tip for anyone who wants to be more engaged in your Nebraska legislature. Submit your written testimony when you come and testify. At least if you're in my committee, I really appreciate it personally. I did see Mr. Riker from the Farm Bureau does have his testimony submitted. So I am going to look it over in the next 5 minutes before I have to do my closing, or maybe we won't get to my closing because I think we're adjourning for the day. So how much time do I have left?
1 minute, 20 seconds.
I will yield the remainder of my time.
Thank you, Senator. Senator Hunt, you're recognized to speak.
Thank you, Mr. President. We will do a refresher on this amendment tomorrow and try to talk to some people, that's so vague. We'll talk to as many of you as we can between now and tomorrow about what this amendment does. What it does is it makes the, it makes the Department of Broadband subject to the Open Meetings Act, is what it does. And the Open Meetings Act, which sometimes is called the Sunshine Law, it's been a really good thing for taxpayers in Nebraska for several reasons. It has increased government transparency. It has provided citizens with access to decision-making process. And it's also helped prevent corruption and the abuse of power. One of the primary benefits of the Open Meetings Act is increased government transparency. And what the law does in Nebraska is it requires all government agencies to conduct their meetings in public, and that allows taxpayers, which the Department of Broadband would be responsible for stewarding the money of taxpayers. The law requires all government agencies to conduct their meetings in public, allowing taxpayers and citizens to observe and participate in the decision-making process. This transparency helps to ensure that government officials are accountable to the public and that their actions are in the best interest of the taxpayers whose money they use. By requiring government agencies to provide advance notice of their meetings and to make audio recordings of their meetings available to the public and the minutes available to the public, the Open Meetings Act has also made it easier for citizens to participate in the decision-making process. Citizens can review meeting agendas and materials in advance of meetings. Nebraskans can prepare comments or questions to ask during the meetings, and they can access recordings and minutes of meetings that they may have missed. Without the Open Meetings Act in place for this board, we will be missing a significant chunk of the accountability that Nebraskans deserve for this new unelected board. Another benefit of the Open Meetings Act is that it has helped to prevent corruption and abuse of power. By requiring government agencies to conduct their meetings in public, the law helps to discourage backroom deals and secret arrangements and agreements that might not be in the best interest of taxpayers. Public scrutiny of government actions also helps to ensure that government officials are held accountable for their actions and are not engaging in corrupt or unethical behavior. The Open Meetings Act has been particularly important in Nebraska, where our state's unique system of government has created a large number of public bodies and agencies that are responsible for a wide range of functions. These agencies, besides the broadband department, they include school boards, city councils, county boards, different state government agencies, among others. The Open Meetings Act basically just ensures that all of these meetings are conducted in public and that they provide taxpayers with insight and access to the entire decision-making process. The Open Meetings Act has also been important in helping to promote civic engagement and participation in Nebraska, because when we provide Nebraskans with access to the decision-making process, the law has helped to increase awareness and understanding of government actions and policies. Thank you, Mr. President. This has allowed people to become more engaged in their communities and to take an active role in shaping the policies that affect their lives. In 2015, I became engaged with government for the very first time by testifying at a school board meeting. Today, with all of the, different very fiery issues that are being handled by school boards, I think that we probably have a lot of future elected officials in Nebraska over the next generation who got their start because of the Open Meetings Act, because they were able to testify in meetings, because they were able to go to their city councils and their school boards and make their voices heard about something that mattered to them. And without that type of access and ability to engage with government and engage with the civic process, these are people who may not have otherwise ever done that, honestly. Thank you, Mr. President.
That's your time, Senator. You're next in the queue, and that's your final time on this amendment.
Thank you, Mr. President. I'd be happy to take anybody's time if they're willing to give me a little more time as well, because I have some more points to make about the Open Meetings Act. Because of the decision of Nebraska to make sure that citizens and Nebraskans, I'm careful with citizens because of course we also want non-citizens and anyone who's a resident of Nebraska or who has a stake in the policies that are passed by these bodies that are subject to the Open Meetings Act. We want everybody to be able to come in and testify, share their views, record their position on an issue. And because of this law that we have, people in Nebraska are able to do that. Overall, the Open Meetings Act has been a really good thing for taxpayers in Nebraska. It has increased government transparency. It has provided citizens and Nebraskans and people who are affected by policies and decision-making in our state to have access to the decision-making process. It has helped to prevent corruption and abuse of power. It has promoted civic engagement and participation. And it has promoted public trust and confidence in government. And that's why the Open Meetings Act is such an important cornerstone of government, and why we need to make sure that this sunshine law, as it might be called, is applied to any new agency or any new board that is created, particularly under the executive branch, because we know that the executive branch has a well-documented in the press, in the courts, et cetera, history of abuse of taxpayer dollars. I don't know if I've heard hardly a bill go by in this legislature without somebody making a point about fiscal responsibility, without somebody making a very important, very conservative argument that when we are stewards of taxpayer dollars, we need to make sure that those dollars are used wisely. But when we give one member of the executive branch the authority to pick their friends, to decide who is going to be in charge or in power on an unelected board, we really give up a lot of that control and oversight. And that is also given up on behalf of the taxpayers who voted for us, who put us here, whose interests we are called to represent as members of a separate body of government, as members of a separate branch of government. So when the legislature, whether you want to support the creation of this kind of thing or not, you want to support having a director of this kind of thing or not, without this amendment introduced by Senator Kavanaugh, and again, I would almost challenge her to withdraw this amendment and ask Senator Brewer to introduce it or Senator Geist to introduce it. She can be running for mayor and say, look at how much sunshine I brought to this new board, and now we have all this accountability. That would be great for her. That's probably the only way we would get something like this adopted. By not doing it, what we're doing in this legislature is giving away unaccountable power, unaccountable responsibility to another branch of government that frankly doesn't need it. Before the Open Meetings Act was enacted, there were no legal requirements for government agencies to hold their meetings in public. And this lack of transparency led to a lot of concerns about backroom deals and corrupt practices, people giving special deals to their friends and family members. And before the passage of this law, citizens had very little access to the decision-making process and couldn't hold government officials accountable for their actions. In the early 1900s, the Nebraska Legislature began to address these concerns by passing laws
1 minute.
that required certain government agencies. Thank you, Mr. President. In the early 1900s, we began to pass laws that required certain government agencies to hold their meetings in public. However, these laws were limited in scope at the time, and at the time, they also didn't apply to all government agencies. In the 1960s and 70s, there was a growing national movement to increase government transparency and accountability. And actually, a big reason for that was the increasing diversity in government. It was in the 60s and 70s that we started to see Black people elected for the first time, that we started to see women elected for the first time, that we saw our first out gay elected official, Harvey Milk, in San Francisco. And because of the diversity of experiences and opinions and beliefs that actually started to reflect the identities of the people they represented, we also saw an increased public interest in transparency,
That's your
openness,
time,
and
Senator.
access. Thank you, Mr. President.
Thank you, Senator Hunt. Senator Conrad, you're recognized to speak.
Thank you, Mr. President. I'd yield my time to Senator Hunt if she so desires.
Senator Hunt, that's 4 minutes, 50 seconds.
Thank you, Mr. President. As elected bodies and boards and places where decisions are made that affect, all of the people in a city or municipality or a state or even our nation, as these bodies became more diverse, the public started demanding a lot more accountability as well, because the people who were representing them finally wanted to give that to them, basically. And in the 60s and 70s, there was a growing national movement to increase government transparency and accountability. This movement led to the passage of the Federal Freedom of Information Act, which we use here. It's used in Nebraska. And in 1975, the Nebraska Legislature enacted the Open Meetings Act. So it was in the middle of the decade in the 70s that finally came to pass in this state. And what that law did at the time it was passed, and it's been amended since then several times, but at the time in 1975, it said that government agencies are required to provide advance notice of meetings, including the time, date, and location of the meeting, as well as the agenda for the meeting. And the law also required that all of these meetings be open to the public, with certain exceptions for matters that were confidential or exempt from discourse under other federal laws. And we have the same process in the Nebraska Legislature. We have our hearings open to the public, even though people like Senator Ben Hansen cuts off debate in an unwarranted way before people have the chance to speak. But in theory, when the system works as it's supposed to, people like Senator Ben Hansen would allow all testifiers the opportunity to speak. And it would only be in something like an executive session where the public then would not be allowed to participate in that. And one thing I like about executive sessions is that it's a chance for us to really speak frankly to each other as colleagues. It's a chance to kind of let down the facade of respectability, I suppose, and talk frankly in regular terms about what we think about a bill. That is exactly what should have happened in the executive session for LB 574, which is the reason this entire session has been held up. The reason why we're not moving on to other bills is because of things that happened in Senator Ben Hansen's committee from the time that he didn't allow everybody to testify on the bill to the time he rammed this bill through in executive session, where, of course, there was no public oversight at that time. Typically, what I think would happen is a good chair, if Senator Ben Hansen had risen to that kind of capacity, in my opinion, would probably keep that bill in committee, knowing what a firestorm it would set off on the floor of the legislature, knowing how controversial that would be, but not controversial like what should the marginal tax rate be, not controversial like LB 574, introduced by Senator Linehan at the request of the governor to reduce individual and corporate income tax rates. Reducing corporate income tax rates is certainly controversial. People certainly have very different views about that. We even have different views about whether corporations are people.
1 minute.
Thank you, Mr. President. My view on that is that if corporations were people, they would have to have a heartbeat. And then all of you would pass laws deciding what we can do with corporations. But what we're going to do for sure probably in this body is reduce taxes for corporations, because that's not as controversial as some other things that we discuss. What Senator Ben Hansen did after he prohibited testimony on the most controversial, the most oxygen-sucking, the most, honestly terrible bill that I think we've seen in the Nebraska legislature in my time is we really lost an opportunity to use our judgment, to use our experience, and to think about what we share as the goals of this legislature for the people of our state. Blueprint Nebraska has been mentioned several times. There are all kinds of experts and research and money that's been put into
That's your time,
figuring
Senator.
out. Thank you, Mr. President.
Senator John Kavanaugh, you're recognized to speak.
Thank you, Mr. President. I would yield my time to Senator Hunt if she would like it.
Senator Anya Hunt, you have 4 minutes, 55 seconds.
Thank you, Mr. President. And colleagues, if anybody else would like to yield me time, I do have some other points to make about the Open Meetings Act. When Senator Ben Hansen allowed testimony to be cut off before everybody in the public had the opportunity to speak on LB 574, and of course, he also did the same thing on LB 626, which was the abortion ban that was introduced by Senator Albright. Many of us thought that that would actually be the bill that took up the most oxygen and the most time this session. I prepared all interim to be focused on that bill. When I came in the very beginning of this session, one of the first things I said was, if you are co-sponsoring or voting for the abortion ban, I'm not voting for your bills. Because for me, that was a line in the sand that I had made clear for many years, but I knew that this year would probably be our last stand in Nebraska to protect abortion access for anybody who needs it in our state. There's kind of an attitude or belief that many people have, which is that wealthy people will always be able to get abortions, that wealthy people will always be able to, fly their mistress out of state to New York or California or Colorado in our case, so that they can terminate a pregnancy if they need to. But what they don't think about are, the folks who have complicated pregnancies, the folks who end up getting terminal fetal diagnosis, different reasons that people need to access health care without being under the watchful eye of the farmers and bankers and small business owners and teachers and whatever other occupations we have in this legislature. We are not healthcare experts. We don't know what's best for Nebraskans and their families. And I think that if we want to be Nebraska nice, as we say we are, we should just trust families to do what's best for them. These are the people who you go to church with. These are the same people who you trust to babysit your children and grandchildren. These are the same people who you bake cookies for as a room parent in your kid's school. These are the people you say excuse me to in the grocery store. And you want to do every kind of thing to be good stewards of their taxpayer dollars. You want to do every kind of thing to give them as much money back on their property taxes as we can. You want to do every kind of thing to reduce the corporate tax rate in Nebraska so that we can attract more businesses here that will make our communities more vibrant and thriving, that will bring more workers to our state, which will improve the culture for the people and neighbors that we care about here. But you won't trust them to make their own healthcare decisions. And nowhere is that laid more bare than in that committee hearing where people were waiting outside for 7+ hours throughout the day, crying, commiserating, supporting each other, afraid, excited, highly prepared, highly unprepared, a huge variety of folks, but all of whom had made the choice that day to come to their state capital in Nebraska, many of them from the Panhandle, honestly. These aren't all Nebraska or these aren't all Omaha people. These are all people who made the choice that day to come, prepare testimony, which is not easy.
One minute.
Thank you, Mr. President, and address their state senators, which, trust me, is not necessarily a relaxing thing to do. It took me a really long time to get comfortable speaking on a microphone, just, not even just this, to say nothing of this, but even testifying at a school board meeting or, I remember up till I was like 30 coming to testify on bills in the state capitol here and physically shaking as I gave testimony to the committee. There's a photo of me from before I was elected when I was just a regular gal. And I was testifying in Health and Human Services. I don't know what the bill was. It might have been a paid family leave thing, or it might have been something, it might have been the Title X funding. That was a big fight one year. And Senator, at the time, Sarah Howard was on the committee, and I was testifying, and the whole time I was just speaking to her.
That's your time, Senator.
Thank you, Mr. President.
Thank you, Senator Hunt. Mr. Clerk, for items.
Mr. President, your Committee on Education, chaired by Senator Merman, reports Legislative Bill 583 to general file with committee amendments. Additionally, motions to be printed, Senator Hunt to LB 562 and 565, 570, 574, 575, Senator Michaela Kavanaugh to LB 580. Amendments to be printed, Senator Kavanaugh to LB 683 and Senator Hunt to LB 683. And Senator Kavanaugh again to LB 683. Name adds, Senator Ballard name added to LB 243, Senator Clements to LB 254, Senator Frederickson LB 276, Senator McDonald 419, Senator Ballard 754. Notice that the Revenue Committee will be having a briefing on LB 243, the committee property tax package, tomorrow morning at 8:00 a.m. in room 1524. Finally, Mr. President, priority motion. Senator Ben Hansen moved to adjourn the body until Friday, March 13th, 2023 at 9:00 a.m.
The question is, shall the legislature adjourn for the day? All those in favor say aye. All those opposed say oppose. Nay. We are adjourned.